In non-prosecution of the PID last occasion, I have received instruction. The order is not uploaded. Perhaps the file will be here.
My lord, may I have your lordship's kind leave to file this appeal without the certified copy? Urgent, this is very urgent matter.
Date of the order?
My lord, date of the order is 27 January and we applied for certified copy on 27 January, but the file is still lying in the court and we have also mentioned it before the court.
We will ask them to issue the certificate.
My lord, because tomorrow is the date before the honorable single judge.
Otherwise, section 5 you have to file.
My lord, I have applied for certified copy on the date of the order was passed.
Right, when we grant leave without the certified copy, limitation will start running from the date of the order. So therefore, we will ask them to issue it today. You file it today afternoon.
My lord,
may I be permitted to know whether it will be on to be mentioned or I have submitted?
Let us see. We'll verify the file. You have given the letter.
Yes. Public interest litigation, it is appearing in your lordship's list. I'll be praying for upgradation of the same.
You please wait. Let us. Today is the first day of the monthly list. Let us see how we progress.
But I am mentioning one matter in which, on 19th February, my lord directed me to file the supplementary ABDB in course of the day today. A paper supplementary paper book in course of the today. I tried to file in the department. Department informed as the main paper book is in the court. File it in the court.
You give.
So I am filing that paper book.
Which is the item number?
No, item number is 113. 113.
Then you keep it with you. To take the file, it will be difficult.
But I have mentioned in the.
No problem. We will take it when the matter is called out.
And Milord, I am also praying let it be upgraded.
No.
The freedom
you
fighter
please
mentioned.
Wait. Let us move the list today. Let us see. Yes.
My lord, under compelling circumstances, my lord, mentioning this matter, already this matter is in your lordship's list in the public interest litigation hearing, but the matter was not called because of it was under 100. This is Jadavpur matter, my lord. Day before yesterday, the elections of the colleges.
No. You want to file a fresh PIL?
Yes. No, not fresh PIL. I'm submitting one supplementary affidavit. Along with the...
You give the letter, let us see. It is running in the list?
It's running in the daily list, not in the monthly list. That's why, my lord,
let us check the file.
Yes, my lord.
My lord, kindly, if the file is have, kindly keep it to be mentioned.
Let us check the file, sir. You don't say what we have to do.
It's replayable.
Yes.
Your lordship's kind leave, my lord. I'm mentioning a matter which was disposed of by your lordships on 25th. My lord, by some mistake, my lord, the name of the arguing counsel has not gone in. If your lordship, my lord, I have
to show it in this list and add the name. Yes.
I'm deeply obliged.
Upgradation of a public interest litigation.
Not this week. Next week, you please.
Matter was taken up on 1st January.
Next week, you please mention. Let us.
January and lordship direct that the matter will be appeared on 6th February.
Let us see. Yes.
My lord, Mr. Bose is there. My lord, in the same matter he's mentioned.
Well, there were two appeals which were disposed of on 24th February 2020. Your lordship disposed of both the appeal and connected applications. My lord, by mistake, the writ petition, including the writ petition, is not included.
My lord, only there are other two corrections. My lord, may I indicate in the first paragraph of my lord's order. My lord, your lordship, it has gone down as in the first page, West Bengal Infrastructure Development Corporation, which carries out construction activities for allotment of flats to general. This should be Shapurji Palonji instead of my lord.
You make a pencil correction and give.
Yes, and also my lord, very well. Other corrections, my lord.
You make both the corrections.
And also my lord, the writ petition stands disposed.
Yes. The last line you add,
including
the petitions also stand disposed.
Yes.
And that correction.
Well, sorry for the inconvenience.
No problem. Yes, please call out.
And company.
Let it reach, sir. We'll pull out the file. It will be difficult. Please wait for 10-15 minutes.
My lord, under compelling circumstances, my lord, I am mentioning this matter. My lord will recollect, my lord, in 2023, my lord had taken up a matter with regard to Jadavpur University security, my lord. Now, my lord, after those orders passed, affidavits filed by the...
Yes, now somebody mentioned.
My lord, let this be also taken up together, my lord.
No, we are not upgraded. We have just given the number. Let us see.
My lord, the only difficulty is, my lord, today there is a strike, the colleges, the universities' examinations are getting hampered. there is a problem with
We are not the administrators of the university.
No, my lord, the situation is I shall show from the judgments of the past past
State, you are the state, you take care.
My lord, I am not mentioning on behalf of the state. This is a public interest litigation.
We'll see.
My lord,
Please
maybe
follow.
maybe ask for the leave, my lord, only just to file.
No leave, you file it in the, no
My lord,
leave.
then we shall file and come and mention.
Yes,
Appellate side, daily list, serial number 1. Monthly list.
What happened, sir?
My lord, I beg to appear on behalf of the respondent number 6 and 7 writ petitioner, my lord. My lord, last order, my lord, have directed the writ petitioner to enter into the premises, my lord.
Your lordship,
and from
last
the
order
appeal.
not been complied with by the respondent.
My lord, the respondent have fallen in, my lord. They have reserved railway ticket for 16, my lord. On 17, my lord, they will be at their premises. The premises is in Uttar Dinajpur, my lord. They are the senior citizen, my lord. They have he has fallen suffering from the fever, my lord. So they have got the ticket on 16, my lord. On 17, my lord.
On 17th, they will attend.
Yeah, my lord. They have the railway ticket
Lordship, this is
reservation,
police
my lord.
What is the police report? On what date he will appear?
On 7, before the single bench is tomorrow is fixed, my lord. And on 17 they will reach their native place, my lord.
কতদিনের সময় চাও সেটা বলো।
17 he will be there in the Raigon. 16 তারিখে টিকিট আছে তো।
এই জজ সাহেবকে বলো যে আমার এতদিন সময় চাই, এই বললেই বুঝে যাবে।
17 তারিখে উনি পৌঁছে যাচ্ছেন।
So they will go and comply with the direction in paragraph 5.
My lord. My lord.
The learned
And
advocate.
one point, my lord, I have talked to my client, my lord, and I come to know that no fruit will be yielded, my lord, if the matter is sent to the mediation, my lord. He want to submit
This is in the order. First he will go to his own house. After that, if it is
Then-
required, then the mediation to be done.
Your clients are respondents 6 and 7.
My lord, repetition.
We have heard the learned advocates for the parties. The 6th respondent is present in court. And a supplementary affidavit and an affidavit has been filed on behalf of the 6th and 7th respondent, undertaking to go to the native village so as to comply with the order dated 19/2/2025. In support of the said stand, the copy of the railway ticket has been filed along with the supplementary affidavit. Along with the affidavit, the said affidavit along with the enclosures is taken on record. The the respondents 6 and 7 shall comply with the undertaking given by this before this court and go to their house on 17/3/2025 to comply with the directions issued on 19/2/2025.
And my lord,
Let the matter be placed or listed on so and so for reporting
and the
complaints.
police will provide the necessary assistance, my lord, in compliance of the my lord.
That is all there.
My
That's
lord.
all there.
My lord, I have twofold submission, my lord. Kindly direct my learned friend to serve a copy of the report. And next one is the order to be passed by which the learned single bench did not pass any adverse order against me.
They won't pass.
Because on 4th it is fixed before.
But you show this order, that is sufficient.
Serial
You
number
please
2.
give a copy of the police report, your affidavit also.
My lord.
Where is your copy of the affidavit? Give it to me. Next.
Serial number 2.
Grateful.
my lord. তুমি একটা জেরক্স করে দেবো আমার কাছে নেই।
I am to the appellant, my lord, dispute between two brothers, they have settled the dispute.
Settle.
Yes, lordship.
The learned advocate for the appellant submitted that the dispute between the brothers have been settled.
Lord, according to writ, I have private respondent, Lord. Settlements, if he wanted to withdraw, that is mean, but settle not, there
Therefore,
is
the
not
learned
settled.
advocate for the appellant seeks permission to withdraw this appeal. The submission is placed on record and the appeal stand dismissed as withdrawn. Next.
Serial number 3.
Short password, my lord. Mr. Om Narayan Rai is appearing for the private respondent. Short password, my lord.
What is this? You can't.
But I am comparative brothers. One of the petitioners appeared, he's a 92 years old.
They are obstructing.
Yes, what I am telling you, Justice, my lord passed an order. Well, he's here, 92 years old. Well, he's from London, doctor.
My lord, police in the name of maintaining peace is prevented him to enter into his own resort land. But if there is a dispute, for example, in my house, the police will follow, no, to maintain the peace, you should not enter into your house. My lord, earlier, page 59, passed an order preventing the state for
What was the relief sought for in the writ petition?
to just not to
Show the prayer in the writ petition. Page.
But they have not annexed the,
petition.
they have not annexed the stay application, my lord.
Well, this petition,
So
my lord,
you
yeah.
please read it from your writ
Yes,
writ petition file.
A writ or in the nature of mandamus under 226 of the Constitution of India commanding the respondent to act in accordance with law. A writ or in the nature of mandamus under Article 226 of the Constitution of India commanding the respondent police authority to take appropriate step in accordance with the law to stop criminal trespassing on a regular basis into the leasehold land to prevent construction at the behest of the respondent. Number 4. Number C, a writ in the nature of mandamus under Article 226 of the Constitution of India commanding the police authority to ensure that work of construction on the leasehold land is not interrupted or obstructed and or interfered with any manner whatsoever by the hooligans at the behest of respondent. Number 4. A writ or in the nature of statutory under Article 226 of the Constitution of India commanding the respondent police authority to certify the transmit the record. Well, just before the short.
Now, what happened in the writ petition? What is the order passed?
My order passed that to maintain the peace.
Oh.
My lord, the point is, my lord, this land was allotted.
But how a writ court can adjudicate that? If you want prevention of, if you want your complaint to be registered, then 482 is there, or 156.3 is there. But how to this jurisdiction? I am not able to appreciate.
No, my lord. What I am my only contention before the police that I should not be prevented.
You give a complaint, they will.
Yes, I made a complaint.
Into the complaint,
but no action is there for the last year.
They will inquire into the complaint. If a cognizable offence is made out, they'll register an FIR, then investigate, then file charge sheet. That is the normal procedure.
Yes, my lord, that is there, my lord.
My lord, may I tell Lordship, my lord, on behalf of state, my lord, this order, the impugned order was passed after going through the report filed on behalf of the state authority. It appears from the report of the state authority, it is reflected from the impugned order itself. That, my lord, once, my lord, on the basis of the complaint lodged by the petitioner, my lord, matter was proceeded with, investigation done, and eventually, my lord, the final report passed. And in the final report, it was submitted before the, my lord, the lower court, that the matter is entirely, my lord, the civil nature, because of the fact that previously an agreement for construction was entered into with the private respondent. Later, my lord, the disputes cropped up. Then both party, they, my lord, put their own, my lord, the security guards in front of that, my lord, particular plot of land. Then, my lord, the disputes now in between those security guards and this person who wants to, my lord, enter into therein. Now, at that juncture, my lord, the writ petition filed, the court said also that since it's a civil dispute, you have entered into an agreement. Now, you say that you cancel the agreement. And the private respondents say, now our right is there, we have invested therein. So, enter civil dispute, but whenever it would appear that there is a disturbance and the law and order problem, naturally the police would take action, proper action. Now the second time also it appeared the police took action. Now, my lord, the final report of the police, my lord, before your lordship, my lord, it is a, my lord, the current, my lord, the final report, the police said no construction is going on there, and both parties are, my lord, they should restrain themselves because of the fact whenever they would try to enter into, then the security guards of both sides, they, my lord, came. And, my lord, that is the, my lord, the main law and order problem, my lord, the situation would cropped up.
My lord, my lord, this is absolutely this versal of learned advocate based on the police report. But this is absolutely manufactured. No one asked the police to file this report.
We will not only we will not only dismiss your appeal, we will dismiss your writ petition also.
No, my lord, kindly.
Sir, this relief cannot be, sir. You please advise your client. Sir, probably there was an agreement. That agreement has...
No, my lord, but that is...
Maybe or may not be. We are not saying
Well,
that.
I am not going on that point, my lord. Let me submit my lord first. He has said something which is not based on fact. He has said something on oath I am telling.
All right, we'll keep this report aside. Still, we'll dismiss
Well,
your appeal.
well, that is how coming, my lord. This land has been given under the Government Grants Act 1895. There is a lease agreement, and the terms of the agreement has overriding effect on any other law inconsistent therewith. The respondent filed several petitions, several court, and all are dismissed. Latest, he obtained a stay order from the commercial court. Annexed order, commercial court also dismissed the application. He filed an appeal before the division bench. That was also dismissed. Now the police, in order to help the unscrupulous promoter, file this report. This is not based on fact, because the building, only 8th floor building has been already constructed therein. And one agreement was executed long back, but ultimately government issued notice. He is representing the government. This is a government land. This is a government land given on leasehold land. My lord judgment order, kindly come to page 59. It was given in PIL. Kindly come to page 59. But in this way, they mislead the court. Kindly come to page 59.
Then you do one thing. Give a copy of
This is completely manufactured.
You file your exception to this.
Yes, that would be better.
My lord, I have already filed my exception in the appeal.
Exception to today's.
Yes. It is not today. It has been filed before the writ court.
No. This is the report dated.
This is, kindly see when this is. When?
This is, my lord, on 24th of February 2025.
24th of February.
That's right.
We have heard so and so. The inspector in charge, Electronic Complex Police Station, Bidhanagar Police Commissionerate, has filed a report dated 24/2/2025. Leave is granted to the appellant to file the exception to the report.
Lord,
Within a week.
leave may kindly be granted to us also, Lord.
Well, he
because
has
I am
no custody. He has no, because 2019 on 10 rupees stamp paper agreement.
Lord, I shall make my submissions once he
Let-
completes.
it-
Once he
it has been
completes,
cancelled.
I shall make
My
my
lord, it has been
All right.
cancelled.
The private respondents are also liberty to file their exception if they so desire.
And Lord, your Lordship, Lord, I am taking the point of maintainability, my Lord. Lordship, will kindly keep it open, my Lord.
My lord, one thing, my lord, my lord's order dated
Page 59.
59.
Lord, he
My lord,
has
that is-
taken advantage.
My lord, state any the transfer of land on the grounds of development agreement, because the land has been allotted for industrial purpose.
We will see. Please make your exception. We will.
We'll mind that.
Next.
Serial number 4.
Great. Yes.
My lord, I'm sorry to interrupt your lordship, my lord. For item number 1, your lordship was pleased to direct the next date for 12th of March. My lord, the petitioners, I'm sorry, the 24th March. Then, my lord, I'm so sorry for disturbing.
Yes. Item number.
But item number 4, I am appearing for appellant, my lord. Service has not been made yet. Lordship, I am paying for time, lordship. So to serve all the respondent and come back.
13.2, your challenge. How is it maintainable, madam? You unnecessarily your burdens. The petitioner, the writ petitioner is the appellant before us. The writ petition was filed challenging a notice issued under section 13 within bracket 2 of the Sarfasi. As the act itself provides adequate remedy to the any person aggrieved, the learned single bench was fully justified in not entertaining the writ petition and disposing of the same, leaving it open to the parties to avail all remedies as available in law. Thus, we find no grounds to interfere with the appeal dismissed. Sorry, madam. Next.
Serial number 5.
5.
But 5 and 6, both are analogous matter. In this matter, the impugn order passed on 18th February 2025. Copy of appeal has been filed, but copy could not be served. Matter relates to unauthorized.
No. What was the prayer in the writ petition?
Prayer is the writ petition to
Implement and execution order dated 2nd August passed by subdivision magistrate.
Subdivision magistrate and thereafter, the appellant before your lordship filed an appeal before the district magistrate. That was rejected. That's why the appeal was, writ petition was prepared. The learned judge in writ petition filed by the private respondent allowed the petition without controverting the, giving any opposition to me to controvert the allegations, my lord.
And you are the private respondent in the writ petition.
Private respondent in the writ petition.
All right.
And
Now,
thereafter,
your
my
client had been found to be as one of the encroacher.
one of the encroacher, but the private respondent in writ petition, in private respondent Ajit Kumar Maithur
Now,
also.
what happened to your writ petition 7808 of
7808 is my writ petition, and 2240 is the writ
what
petition.
happened to your writ petition?
My writ petition, I have challenged the writ petition on the ground that my prayer has not been allowed by the learned district magistrate. And that's why I have filed. But I am not only the encroacher, the private respondent also the encroachers. The learned judge did not whisper at all in the order passed by the learned judge. That's why the appeal.
No, in your writ petition 7808,
yes,
is there any interim order?
No, there is no interim.
Then what to do? Subdivisional magistrate passed an order. That order, you challenged it before the district magistrate. That has been confirmed. That you have challenged it in WPA 7808 of 2024. If there is no stay, they have to implement the order. What to do? Your contention is the land is not an highway land. Two authorities are found against you. You move for stay. You move your writ petition.
That my writ petition was dismissed by the learned judge, and the writ petition filed by the private respondent, that was allowed.
All right. Against the dismissal of your writ petition, did you file an appeal?
Yes, my lord. 7808 279. I have.
Next item. Please give the next file. 279.
MAT 279.
279 is a writ petition. I mean 2240. You give the other file.
280, my lord. Sorry, my lord.
280.
280, my lord.
Let us see what it is. Sure. 2240. Oh, wrong with it. Common order. Okay. It's a common order.
It's a common order, my lord.
That you please tell me.
Sorry, my lord.
7808 is dismissed. 2240 is returnable by 8th April.
Yes, my lord.
Recording compliances.
A field inquiry was conducted.
That report was not given to me, my lord.
So the other writ petition is pending. In that you canvass the ground that the petitioner in 2240 is also an encroacher.
He is also an encroacher, my lord. That point was not considered.
That you canvass it in the other writ petition which is pending.
That is pending.
2240.
Yes, my lord.
But why you file two appeals? The other writ petition is not disposed of.
Because, my lord, that writ petition order was passed, my lord. Kindly see the impugn order. The learned judge directed the authorities to remove the unauthorized encroachers within 4 weeks from the date of communication of the order.
Correct, sir. That is because your writ petition 7808 was dismissed. So far as 2240 is concerned, that is still pending. Why did you file two appeals?
Because in that petition, learned judge allowed his prayer.
Okay.
Allowed his prayer. That's why I have filed two appeals, my lord. Without providing me a report and other documents,
then you file a review. See, if according to you adequate opportunity was not granted, you file review. We will give that liberty. You file a review before the judge saying that report was not given to me. I was not given time to file an affidavit in opposition. The petitioner, the appellant, has filed these two appeals challenging the common order dated 18/2/2025 in WPA 2240 of 2024 and WPA 7808 of 2024. The appellant had filed the writ petition in WPA 7808 of 2024, challenging the order passed by the district magistrate, who confirmed the order passed by the subdivisional magistrate Egra, dated 2nd August 2023, under the provisions of the West Bengal Highways Act 1964, holding that the appellant is an encroacher of highways land. The learned single bench examined the matter, took note of the records which have been produced by the learned advocate representing the state respondents, and also noted that yes, field inquiry was conducted and a report was submitted by the Block Land and Land Reforms Officer, Egra 1, certifying the said land belongs to PWD within bracket roads. Furthermore, the learned single bench found that regular show cause notice was issued to the appellant / encroachers, and upon hearing the necessary parties, order of eviction was passed. Furthermore, the land was also demarcated. Demarcated. The learned single bench found that the allegation made by the petitioner that the land does not belong to the Public Works Department within bracket roads is contrary to the report drawn by the Block Land and Land Reforms Officer. Thus, the learned single bench concluded that the land in question being a land of the Public Works Department, the encroachers are liable to be removed. The learned advocate for the appellant submitted that the copy of the report, field inquiry report, submitted by the Block Land and Land Reforms Officer, Egra 1, was not furnished to the appellant, and the appellant had no opportunity to put forth their contention nor file their affidavit in opposition. If such is the contention raised by the appellant, the only remedy available to the appellant is to file a review before the learned single bench, as this court cannot test the correctness of the order passed in the writ petitions based upon material or submissions which were never brought on record. Therefore, we are not inclined to entertain this appeal. However, liberty is granted to the appellants to file review application before the learned single bench, if so advised.
Lordship, kindly allow me that already directed within the concerned police, within 2 weeks, the building will be demolished. So, Lordship, kindly limited stay for 2 weeks. Otherwise,
tomorrow you file. Sir, we will return the original certificate copy. You want the original certified copy?
Lordship, for the purpose of review, I have filed this through server copy. So, Lordship, they kindly give me no coercive steps taken till the, Lordship, kindly within a 2 days,
Two authorities have filed. Please, next.
So, within 2 days, I file a review.
Tomorrow, right away, you start preparing. The same grounds will be review grounds. You file it. Next.
Serial number 7.
The building will be demolished. That is the problem.
In this matter, my lord, I am for the appellant, my lord. The matter is, my lord, due to appear, my lord, on 4th, my lord. The matter is due to appear on 4th, my lord. Instead of 4th, my lord, the appear in this matter today, my lord.
Application is not there.
This is not group 9. But it went before. Group 5 matter or a group 9 matter?
Group 5. My lord, it was
out of group 5 matter, panchayat matter, it was contempt rule was there. In contempt rule, the learned judge modified the order from the read court's original
Since
matter.
the appeal arises out of an appeal is against an order passed in a contempt petition in a writ petition filed under group 5 classification. Let this appeal be listed before the Honorable Division Bench, having a determination to deal with group 5 intra-court appeal.
My lord, this is under contempt rule one order.
Contempt rule, my lord.
It is our
Under
discretion.
latest
This
patents,
is a contempt rule,
clause
my lord.
515.
This court, my lord.
We are sending it there. Next.
Serial number 8.
But I am for the appellant, but
Then we'll add up. Sir, after obtaining appropriate orders from the Chief Justice. Item 8, sir.
but the matter I am told, my lord, is to be notified to be appeared on 5th. Maybe by mistake it's appearing, that's why the state council may not be here. And it will be unfair on my part to move the matter in his absence.
This is a group 9 matter.
Yes.
So let it come on 5th. List on 5th
Joining
in the admission list.
Serial number 9.
My lord, I appear on behalf of the appellant. This appeal
My lord,
arises from an
item
order-
number, before my learned senior friend starts, I apologize, my lord. Item number 9 and 10, my lord, have been led by learned advocate general. But I'm just seeking for a short passover, if my lord may. 9 and 10. I'm the respondent number 1 writ petitioner, my lord.
My lord, I will not stand in the way if the Advocate General is appearing. The only thing I would like to tell your lordship, the appeal arises from an order passed on a writ petition before the learned vacation judge. On the first day itself, the petition was disposed of. I'm Reserve Bank of India. Admittedly, I had not been served. It is available from the records. Naturally, I could not be heard. And thirdly, whilst disposing of the writ petition, my lord, the learned single judge has directed the Reserve Bank of India to do something and perform an exercise which is barred under statute.
Is it a fact that the writ petition was disposed of on the admission?
On the admission, man, that is a fact, my lord.
Without notice to them?
My lord, no, we have served notice, my lord. I'm carrying the affidavit of service. So Mr. Dotto appeared before the learned single bench as well, my lord.
Well,
And
I
just
just
why
told
I'm
your lordship
praying for a
one
passover so that he can
I leave it to
appraise your lordship on this fact, my lord.
Page 160.
Page 169. My lord, I'm not standing in the way of what my learned friend is saying, but since my learned friend categorically says that notice has been served.
No, they should be heard, no, sir.
Yes,
Your
obviously.
application for compounding of the offence was returned.
My lord.
And grievance of the writ petitioner was, it was not disposed of.
My lord.
The learned single bench virtually allowed the writ petition, directing you to resubmit it and to issuing a mandamus to them to consider within a time frame.
My lord.
First, if they say that there is a statutory embargo from doing so, they should have been heard. Probably affidavits need not be called for. Some report or some submission should have been. And the email returning the application is quashed. We can do one thing.
My lord.
We can restore the writ petition to the file of the single bench. Let them file a short affidavit.
I've been led by Mr. Bhattacharya.
Yes. Sir, the admission stage, it has been allowed.
My lord, if my lord kindly takes the order.
You read the order.
But there is no prejudice which has been caused. I have seen the grounds, my lord, they have made out in the memo of appeal. Now, in the memo of
Maybe,
appeal.
sir, maybe their stand is absolutely vexatious. But they are required to be heard in the matter.
But let us do this, my lord. Let me file a short affidavit, my lord, annexing.
No, why should you have an opportunity?
My lord.
When you plead that they shall not have an opportunity, we are not going to give you an opportunity.
Our ground was, my lord, violation of the principles of natural justice insofar as, my lord, consideration of the application is concerned.
The court will consider. That the court will consider. This intra-court appeal by the Reserve Bank of India is directed against the order dated 30/12/2024 and WPA 31029 of 2024. By the said order, the writ petition has been allowed without an opportunity to the appellant to place their submissions before the learned writ court. The learned single bench has quashed the email dated 4/10/2024, by which the Reserve Bank of India returned the application filed by the writ petitioner for compounding of an offence. The learned single bench further directed the writ petitioner to resubmit the application dated 12/2/2024 before the respective authority of the appellant, and a direction was issued to the appellant to consider the same within a time frame. The learned senior advocate appearing for the appellant, Reserve Bank of India, submitted that that the appellant did not have adequate opportunity to rebut the claim made by the writ petitioner, and apart from that, it is submitted that Section 15 of the FEMA is inapplicable to the facts and circumstances of the case. In our view, it may not be always necessary for the writ court to call for affidavits. Nonetheless, an opportunity should be granted, more particularly when the court is inclined to allow the writ petition at the admission stage.
Madam, we kindly appreciate, Madam, the affidavit of service, Madam, we are carrying, Madam, the photocopies. They were served, Madam, service was effected on the 26th of December, which they have not mentioned, Madam, in the stay application. They say that we.
Page 169. I have mentioned
the
that.
respondent
It
writ
was
petition
served on the
submitted.
But the
30th.
copies are there, Madam.
Notice in the writ petition was
Their-
served on the appellant.
Their ground is,
On 26/12/2024.
but their ground is that they have
served
received it
on
on the 31st.
It may
That is
be
not the
true.
case,
It
Madam.
may be true that the notice was served on 26/12/2024. Nonetheless, however, the writ petition came to be allowed on 30/12/2024.
Madam.
Considering the facts and circumstances of the case, we are of the view that adequate opportunity was not granted to the appellant. Therefore, we are inclined to set aside the impugned order and restore the writ petition to the file to be heard and disposed of afresh on merits, after affording an opportunity to the appellant to file their affidavit in opposition. Accordingly, the appeal is allowed, the order impugned is set aside, the writ petition is restored to the file of the
Madam, I'm being
learned
led by
single
the
bench.
learned advocate general,
Yes,
Madam.
learned single bench, having determination, full stop. The appellants are directed to file their affidavit in opposition within a week from today. Reply, if any, within a week thereafter. Let the writ petition be listed before the learned single bench, having determination within the after 3 weeks. The learned advocates for the parties are at liberty to mention before the learned single bench having determination for early hearing of the matter. It is made clear that we have not expressed anything on the merits of the matter. It will be well open to the parties to agitate their respective claims before the learned single bench.
My lord, kindly recall
Your
one
lordships, have
submission
you
of
please to
mine
pass
that
the
it
order?
was served on the
Give me one
31st of December.
Permit me to say one sentence.
Many a times, state is served. Today, 4 matters, state has been served.
I have
long
got,
back, they are not appearing.
there's a stamp.
Wait, sir,
There's a
please,
stamp.
please. But still, we check the date of delivery, speed post. If there is reasonable time, here the writ petition is being allowed. Sir. Some
Anyway,
reason.
I have got the
But
order.
here, my lord,
The only
what
thing
has,
which I
what the
wanted to tell
learned
you-
single judge has directed is you hear the petitioner's compounding application, that's all.
Yes, sir.
And well, under the compounding rules, my lord, they have to give me a hearing. Because they did not consider
But then may I
the
file the
compounding
affidavit of
application returned.
service?
9 and 10 same orders. Next.
Or, my lord, may I, my lord, request your lordships to hear out this appeal? Whether, my lord,
Heavens won't fall, sir. It's a compounding application. It's been returned.
Already in terms of.
Economic offenses.
and will we have resubmitted the compounding application in terms of the
Doesn't matter.
learned single judge's order.
Grateful, man.
This order is appealable.
Very grateful.
Next.
Serial number 11.
11, my lord.
Hmm.
The Waqf, my lord. Issue, my lord, is Lordship knows, my lord, there was comprehensive amendments of the Waqf Act with effect from 1st November 2013. And one of the amendments in the definition of Matwali was that he shall be an Indian citizen. So, my lord,
No,
that
the
was
appeal has to be heard.
has to be heard.
Appeal has to be heard, my lord. We are the writ petitioners.
When we will
My lord, Lordship,
As a
but
lordship.
there are no, Lordship.
you have to come in the queue.
No,
No, I am just on a different point. There are some preliminary submissions to be made in this matter. That is, for example, one, it's a federal statute, but Union of India is not a party respondent.
If you file an application, we'll allow that.
Secondly, my lord, the Waqf board is a party respondent, but Waqf board is a mere one of the parastatal bodies under Minority and Madrasa Education Department of Government of West Bengal. I am for the Waqf board. We are being appointed, or we are being established by the Minority Department of Government. So, Government of West Bengal is also not a party respondent. Moreover, Section 109 and 110 of the Waqf Act have given rule-making and regulation-making power to the Government of West Bengal. Board is appointed, established by Government of West Bengal in the Minority and Madrasa Education Department. So they should also be pleaded as a party respondent. Government of West Bengal in the Department of Minority and Madrasa Education.
And Union of India.
And if it's a federal statute, they have made Waqf Council a party. Waqf Council is mere an advisory body.
Waqf Council is not.
They cannot represent Union of India. Kindly have a look at the, my lord, the writ petition.
And what was the prayer in the writ petition?
Prayer in the writ petition, my lord, since he is admittedly a foreign national, but is a matwali of a Waqf state. Taking note of this particular amendment of 1st November 2013, we brought this particular on board meeting, saying that you are deemed disqualified because there is an amendment with effect from 1st November 2013 that the matwali shall be an Indian national.
Could he not have gone under Section 83?
Should be, but at that point of time, my lord, the Waqf tribunal was not functional. Point number one. Point number two, they alleged that there is violation of principle of natural justice because I was not given a proper notice for the meeting.
No, that can be agitated before the tribunal because there are several decisions of Supreme Court. In fact,
Yes, the Lordship knows 2010 volume 14 SCC,
which says
your Lordship was pleased to hold also several.
The Waqf Act is a complete code by itself, and the civil court is denuded of jurisdiction.
Section 85.
85. So 83 appeal to the tribunal. Its fact-finding inquiry can be done by the tribunal.
So my learned friend's plea on that day when the writ petition was filed is it is not functional. And secondly, there is violation of principle of natural justice. Whirlpool Corporation 1998 volume 8 SCC 1, that if there is violation of principle of natural justice, I can directly invoke that.
Now the appeal is against an interim order granted in the writ petition.
Against the order passed by the Waqf board.
No.
Millet, the final order, Millet, in the writ petition. Writ petition
Not
is
interim
disposed
order,
of.
final disposal.
Final disposal of the
Without
writ
calling for
petition.
affidavits.
Which is the final order? Page?
Millet,
Will you kindly take the memo, Lordship?
Millet, 66, Millet. Page 66.
No, we'll
Memo,
go by
memo.
the memo.
Of the application also, Millet.
Memo.
And how does the learned single bench deal with this objection? But on the date when the writ petition was disposed of, tribunal was functional?
No.
No.
Millet.
If
No,
now,
Millet.
as of now,
Now it is very much.
Now it is functional, Millet. At that day, Millet, it was not functional.
Page 57 was the challenge in the writ. Kindly have a look at the stay application, my lord. Page 57 was the challenge in the writ petition.
but the learned judge says Section 64 doesn't provide for
Three disturbing observations have been made in my respectful understanding. One is that 64 concept has been put in by the Honorable Single Judge. Your Lordship will not find any whisper throughout the resolution. Learned Judge has whispered this particular concept into this resolution. Kindly have a look at 57, no whisper. We are not removing. He is deemed disqualified by operation statute. Second disturbing observation, Honorable Single Judge, with deepest of respect, he says Matwaliship is a vested right, cannot.
No. It's not a vested right.
Third disturbing, my lord, observation is that the proviso which was added by the Amendment Act of 1st November 2013 that he should be a citizen of India should have prospective effect. So since he was appointed long before the amendment came into operation, he cannot be disturbed.
Let's see the provision which was.
Lordship. Lordship kindly comes to the definition clause, my lord.
No, before that you should just show the order which was impugned in the writ petition.
To page 57?
57.
Of the stay application, Lordship.
You didn't appear before the board. First hearing, your client appeared through a power agent.
My lord.
Then thereafter, he appeared through an advocate.
My lord.
Thereafter, they fixed a date as per your convenience. You did not appear.
My lord, what we have written, even in the impugned order, which my learned friend has challenged, a mail was also written to the board about an address and email ID was also provided. That is also given in the impugned order, my lord. But they have never served the notice on those addresses.
The address which my learned friend is referring to and where we have served upon the notice, my lord, Lordship kindly comes to, my lord, page, my lord, 65 of the stay application. Page 65. This is the notice of meeting. Page 65. From Ahsan, the CEO board, and to kindly says Irfan Ali, petitioner. This is the address which was given by him. Kindly sees at page 54. This is the address which he had furnished to us at page 54. Letter addressed to the CEO kindly sees dated 29 September. That I had advised Syed Irfan Ali so-and-so. I had advised you in previous correspondence that I would be managing myself on the complete hands basis. I have been doing so since I dismissed my manager Muhammad Aslan so-and-so. By the grace of Allah, everything is fine. Now kindly say, please send, last line, please send any replies and correspondence to me at Market Street, 26 by Market Street. And also to my email. Now he takes a point, I had given my email ID too. Why didn't you send it to me? That is his point. But I have sent it to his Market Street address, which he had furnished to me.
Milord, another letter is missing, Milord. There was another letter by the writ petitioner informing them that he has changed the address. Now, that is not annexed, Milord. That has to be shown, Milord, because that is also on the basis of which the impugned order was passed.
The problem is, your client is not in the country.
Milord.
That's the problem. He is staying outside the country, and by remote control, he is trying to run the work.
Milord, he comes to the country also, Milord. He was here last week.
The order which is impugned in the writ petition does not remove him from the post of Mutawalli. It says he is expunged.
Why? Because by operation of law, Milord. Yes. This is what they have submitted before the learned single bench.
Let us see the prayer in the writ petition.
Milord, at page, Milord, 37 is the writ. Prayer clauses, Milord, at page 48. At page 48 of the stay application.
There was no prayer to read down the.
No, certainly not. He says that setting aside 29th February, that is page 57, he wants setting aside of page 57. And certiorari is simple, that's it. His ground is simple, that there was violation of principle of natural justice. Assuming that he is correct, because 1998, volume 8, SCC, page 1, Whirlpool Corporation up to 2020 says if there is violation of principle of natural justice, you can invoke 220C despite any alternative remedy. But honorable single judge, without going through that, has entered into the merit of the case that whether a foreign national can be or cannot be. Milord, it's a very larger issue.
Milord, that kind of submission was invited from my learned senior friend's side, Milord, the Waqf board has invited this submission. Milord, kindly see, Milord, the prayer which he have prayed for. And Milord, kindly correlate what we have challenged. What we have challenged, Milord, that I have been basically, Milord, the baseline is we have been removed from the mutawalliship, Milord. From that order, Milord, passed by the Waqf board. We have challenged this. During the process of deciding that, the most important and crucial part was whether, Milord, I being a foreign national, under the new amendment made to the definition of mutawalli, Milord, whether I am falling under that thing or not. They are saying my name is expunged.
That was not the question at all. All that you should have asked is to set aside and remand the matter back to the Waqf board.
Milord, on the entire issue, Milord, why, Milord? Because I was suffering, even there is a stay order by my Lord, Milord, in this matter. Right now, Milord, I am suffering.
Now, Milord, not suffering. The
income generated from the Waqf property, Milord, my Waqf property, that we have actually, Milord, ceased to receive because of this matter being pending.
No, the second proviso was inserted by Act 27 or 13 with effect from 1/11/2013.
Lordship,
Malord.
See, the mutawalliship is what you say. On the date when the amendment came into force, you stand statutorily disqualified.
May I throw focus on another aspect of the matter? Milord, the first pan-India legislation of Waqf law is, Milord, 1954 Waqf Act. Post-independence, pan-India. But 1954 Waqf Act, parliamentary statute, had given option to the states you can adopt, you may not adopt. Bengal, UP, Bihar and Orissa did not opt to adopt that particular act. So what was Bengal Waqf governed by? Bengal Waqf was governed by Bengal Waqf Act 1934. It's a colonial piece of legislation, Lordship. Bengal Waqf Act 1934 also had a provision that the Matwali shall be a citizen of India. In the year 1975, 1934 Act itself underwent an amendment saying that, all right, if you are a Matwali and a foreign national, you can administer the Waqf estate in the political trait of India through a nominee. So their right had already gone in the year 1975. They were acting through nominees. As your Lordship gets one name over here, Ethesam or something, he had been acting through that nominee. But the moment 1st November 23rd Amendment takes away their right totally, now they have the entire.
Actually, what you should have done is, you should have challenged the second proviso, saying that it cannot be retrospective. All right. Is it a case that once a mutawalli, always a mutawalli?
Certainly not.
Certainly, Milord.
Lordship knows in the Waqf
why I am saying, Milord,
in the Waqf
submission,
it's not a Milord,
by humble
right of Matwali.
What if the matter goes back to the Waqf board for a fresh decision? Because he did not have an opportunity to address this.
So Lordship is proceeding on the point of violation of principle of natural
Only
justice.
on that. We will vacate the other findings.
Lordship, Milord, kindly indulgence, Milord, only one indulgence, Milord. Milord, kindly keep this matter as to be mentioned, Milord. I'll just take one instruction, Milord.
Your client won't agree. We will protect whatever is the intermodern now. The properties, some interim order we passed.
Lordship was pleased to pass that. Kindly have a look. Only one order
Still-
was passed on, my lord, 8th July 2024.
See, a writ court cannot go beyond the scope of the writ petition. If you had filed a supplementary affidavit, questioning the second proviso, or praying for reading the proviso, reading down the proviso, or prospectivity, retrospectivity, etc., what will be the position? Because they have an argument. After 1975, what right you had to that itself is gone.
They did not challenge at that point of time why it was gone. Today, when entire thing has been taken away in 2013,
Did you file your affidavit in opposition?
I was not given the opportunity.
Millet, they never prayed for Millet. They outrightly, they just went it with the hearing of the writ petition. Millet.
As because, my lord, I also raised a point of committee of court. Committee of court in the sense, same issue. With regard to Bangladeshi national Matwali, there is a civil division proceeding which is almost at the fag end of its, my lord, argument. Honorable Justice Shampa Sharkar is in season of the matter. Mr. Jishnu Chaudhary is my other side. There the Bangladeshi national of a Waqf state is involved, but it is in the civil divisional jurisdiction side. So I took a point also, Lordship will find reflection in the impugned order also, that committee of court, my lord, says that since that issue, same issue, although in a different proceeding, is almost the fag end. So Lordship may kindly, but Lordship got very angry, why are you raising that issue, this issue and all this, Lordship. So I have annexed that order also. So this matter, Lordship, Lordship, this matter, Lordship may relegate back to the Waqf board if your Lordship so
Going beyond the
Certainly, Millet.
Relegate
I'm
it
being
back.
led by Mr. Siddiqui Millet
Yes,
in
sir,
this
please.
matter. Millet.
I just overheard Mr. Gali Malad saying that since the matter was pending before the Malad, what is sauce for the goose is sauce for the gander. He's a statutory authority. Then he should have waited for the outcome of that particular
No.
matter.
What was the
Malad,
prayer?
he rushed in removing
Your
me.
prayer in the writ petition, pleadings was a simple case of violation of principles
So
of law.
natural justice. Malad wanted
And
to.
where is the question of the
But
writ
he
court?
raised that issue.
No.
But I still distinctly recall, my lord, it is the learned counsel for the board of Waqf who
No,
raised that
no,
issue. I said, my
prospectivity-
lord, you should have removed me, given me a notice.
No.
I had sent a mail that this is my email ID. You should have sent me a mail. Nothing was done. Behind my back, my lord, but I'm compelled to say they want to use up my property.
No, because the court had no occasion to adjudicate whether the second proviso is prospective or retrospective, because it was never your case. Your case was plain and simple, that no adequate opportunity.
That was
And even in your letter which you had addressed, saying that all is well.
Page 50.
My manager, since I dismissed my manager so and so for gross fraud and wrongdoing, sole beneficiary so and so. Now you are not even managing the Waqf estate.
I am
through an agent. You dismiss the agent also.
No, that agent is instrumental in asking the board of Waqf to get me removed. That agent is because
That was
I am
your appointee.
No, I am managing the property. You should not acknowledge my any appointee. You have appointed me.
1934 Act, they lost
My
the
lord,
right.
that is
That's
what
why
I am
he
on.
appointed this
What-
gentleman.
He will send it back to the board. He will adjudicate. Then you have got your right under 83 because of 85. 83, that route you come. Then you come to
What
the
tribunal?
Then this come 1995 Act comes.
So, my lord, page 757, Lordship is quashing.
Page 57, yes. This intra
On the issue of principal violation.
Yes. This intra-court appeal is directed against the order dated 21st May 2024 in WPA 13765 of 2024. The said writ petition was filed by the respondent herein, praying for issuance of a writ of mandamus to set aside the order dated February 29, 2024, passed by the second appellant, correct?
Lordship.
Second appellant, holding that when the question of Indian nationality of Syed Irfan Ali, the Mutawalli, is involved, and also considering the fact that for want of proper administration and management, a valuable Waqf estate is being hampered, and after due deliberation and discussion, the Board of Waqf West Bengal held resolved that the name of Syed Irfan Ali, within bracket writ petitioner, be expunged from the post of Mutawalli in respect of Syed Masuluddin Waqf estate. On going through the writ petition, more particularly the grounds which were raised in the writ petition, we find that the case of the writ petitioner was that the order dated February 2029 was passed without providing the writ petitioner any opportunity. Further, it was contended that the board failed to effect any service of notice of the purported hearing, and therefore the order was in violation of the principles of natural justice. In the writ petition, in the prayer sought for in the writ petition, the writ petitioner did not seek to challenge the amended definition of Mutawalli, whereby the second proviso was inserted by Act 27 of 2013 with effect from 1/11/2030, which provided further that Mutawalli shall be a citizen of India and shall fulfill such other qualifications as may be prescribed. Therefore, the board of Waqf has held that by operation of law, the writ petitioner cannot continue as a Mutawalli as admittedly the writ petitioner who is a British national. Full stop. Thus, the learned writ court had no occasion to examine the effect of the amended definition of Mutawalli as defined in section 3 within bracket small I of the Act after it was amended with effect from 1/11/2013. In other words, there was no prayer sought for in the writ petition either to declare the amendment as ultra vires or to hold or challenging the amendment to be prospective and not retrospective. Therefore, we are of the view that the observations and finding rendered by the learned writ court on all such aspects was beyond the scope of the writ petition and have to be necessarily eschewed. We say so because the court, at the instance of the writ petitioner, was not called upon to decide as to the effect of the amendment, as all that the writ petitioner contended was the order impugned passed by the Board of Waqf was in violation of principles of natural justice. Apart from that, the observations/findings rendered in the impugned order may have far-reaching consequences, and such findings could not have been recorded without an affidavit in opposition being filed. In the instant case, even an affidavit in opposition, if had been filed, it may not address the issue, as the prayer sought for in the writ petition was not to declare the statutory amendment as invalid or ultra vires. Therefore, we are of the view of thus the only question which fell for consideration before the learned writ court was whether the Board of Waqf West Bengal afforded reasonable opportunity to the writ petition. On going through the order impugned in the writ petition dated February 29, 2024, we find that the matter was adjourned twice at the instance of the writ petitioner, and it appears that a notice was sent fixing the hearing on February 29, 2024 to the address given by the writ petitioner Mutawalli, and the envelope returned with the endorsement, inverted comma, no such person in this address, inverted comma, close. The learned senior advocate appearing for the appellant, appearing for the writ petitioner submitted that in the letter dated September 29, 2023, the address of the writ petitioner was given as 26/1, Market Street, first floor, Kolkata 700087, to which the notice of hearing fixed on 29th February 2024 was sent. However, it is the case of the writ petitioner that there was another letter which was sent to the Chief Executive Officer of the Board of Waqf, intimating the change of address as well as the change in the email address, which has not been annexed in the in the stay petition filed along with this appeal, and notice and admittedly notice was not sent to the new address which was notified. In our view, the writ petitioner had don't say now. Admittedly, the writ petitioner had responded to 2 earlier notices, and though he did not appear personally, he had authorized Mr. Farooq Ali, learned advocate, to appear in the hearing on November 23, 2023. Thereafter, the next hearing was fixed in February 2024, and the notice sent to this address has returned with postal endorsement. No such person in this address, inverted comma close. Thus, we are of the view that the writ petitioner should be given adequate opportunity, more particularly when he had appeared through his authorized representative in the hearing held on 23/11/2023. Therefore, on this ground alone, we are inclined to interfere with the order passed by the Board of Work dated 29/2/2024. Accordingly, the appeal is allowed, and the findings and observations rendered by the learned single bench touching upon the effect of the amendment to the Waqf Act 1995 with effect by Act 27 of 2013 with effect from 1/11/2013, the insertion of the second proviso to section 3 within bracket small I are set aside. As we have found that there has been violation of principles of natural justice, the order passed by the Board of Work dated 29/2/2024 is set aside, and the matter stands remanded to the Board of Work for fresh consideration. The Board of Work shall the writ petitioner is directed to appear in person or through representative before the Board of Work and submit a letter clearly mentioning the correct address and the email ID. On the said date, the Chief Executive Officer shall fix a date for hearing, and the appellant and the writ petitioner shall appear and place all their submissions before the Board of Work, which shall be considered on merits and in accordance with law. We make it clear that all other observations made by the learned single bench touching upon the validity of the amendment, its prospectivity or retrospectivity, and all other related issues are set aside, and all legal and factual issues are left over.
Only one humble prayer, your lordships, my lord, just noted down that in the writ petition there is no such prayer seeking challenging the virus of the particular. Your lordship may kindly note down, my lord, that we have also said, my lord, that this particular amendment is not retrospective; it is prospective.
So no, that is why we said all issues, including legal and factual, left open. It will be we further make it clear that it will be well open to the appellant to raise all issues as regards the validity of the amendment, etc., before the Board of Appeal.
I'm grateful.
Lordship, may I respectfully hand over the certified copy because it was filed on leave.
Certified copy of the impugned order taken on.
My lord, the address may be furnished forthwith.
On that date, when they appear, on that date itself, you give the.
They will not appear without serving notice. So they will have to give us the notice, the address where we have to send the
No,
notice.
they will come to your office, give the letter with the address and email ID.
Lordship, kindly.
That
Sir,
we have
Mr. Ali
said.
is here, he will give it.
On that
Sir,
day,
please.
you fix the date of hearing
Lordship.
and take an acknowledgement, matter is over.
Lordship.
And better he can come. He's in London, is
No, he's here. My lord, 4 times a year, my lord, he's coming not to, for this purpose only. He's an aged man, but he's coming regularly.
Sure. Next.
Serial number 12.
My lord, the small point that is involved today now is, after what has fallen from my lord, is very simple, my lord. Kindly come to the earlier order, which my lord was pleased to pass, my lord, on 20th.
Before my learned senior friend apprised the Lord, there was a direction upon the state to file the records of the case, my lord. So, my lord, I am ready with the record of the case. The officer is present, my lord. May I respectfully hand over the record?
This is that marriage register.
Marriage register. Now, my lord,
Marriage register, my lord.
I'm appearing for the respondent.
Private
Writ application, here also the respondent.
The Shia MMR, the new appointee.
my lord, my first point was, my lord, with all humility, that both the act and the rules have not been followed here. Now, when I read this point, I also took a point, my lord, that there was no vacancy. If my lord kindly comes to page 100 of the writ petition, kindly comes to page 100, my lord. This is the yes. Kindly comes to page 100, my lord. Kindly see the date. This is, my lord, the president of the ruling party, my lord, without referring to any act, any rule, says, I would like to recommend you the name of the private respondent for the application of becoming a Muslim marriage registrar. Kindly look into the matter and do the needful, hoping for an early positive response. This is how it started. Now, my lord, kindly come to page 102. This is, my lord, 23rd March 2017. Thereafter, my lord, 28th March 2017, kindly see the application. Application says, my lord, with due and humble respect, I submit that I am, respondent number 8, I am an educated and unemployed youth. And if I am appointed to the post of MMR of Shia community of the area, will be benefited as there is no permanent MMR subcategory Shia in the police station of Bhagangola. In the above facts, I pray to you to consider the temporary Muslim marriage register for sub-custom jurisdiction in so and so. Now, here kindly see there is no question of any vacancy. Nothing.
No, that is why we passed the order.
Yes.
Where is that order?
That is 23rd September.
You please take that order. We'll cut it short.
Yes. 23rd
Official
September,
respondents
kindly
are
see.
directed to produce the original file to establish that on the date when the district registrar Murshidabad reported the vacancy to the Inspector General Registration on July 22, 2016, there existed a vacancy for the Shia sect in so-and-so for the post of Muslim marriage.
2 points, my lord. Kindly consider this. This order presupposes that the district registrar has reported a vacancy.
No.
Sorry, subject. When the district registrar report.
Yes, yes.
So I joined issue there. Kindly see 1 or 2 pages. The entire document which was there according to them, my lord, from 22nd July 2016 did not surface till the impugned order was passed. There was no question. This document, kindly see it's 165. Kindly come to page 165, my lord. I will come. What they say, I will definitely show what they have said. Let me show that first and then I will take my lord to somewhere else. Kindly come to page 13 of the opposition. Kindly come to page 13 of the affidavit in opposition. 165, my lord, kindly see, is 23rd July 2016 of the petition. I will show, my lord, that this is kindly for
167.
No, not 167, I will come. Kindly see the date, my lord. The memo is 772. Kindly come to 284. I have given this just for 284. Kindly see on this memo. Kindly see 772, the biodata of MMR with so and so. This memo does not reflect that any vacancy exists. But kindly see the register of letters issued. Even then, assume that this document is genuine. Assume. I will make my submissions that this is not a genuine document, but assume for the time being. Kindly see paragraph 13, page 13. Kindly see of the opposition. R. 3R. There was no vacancy at all. This was created. And the state government is not taking responsibility. Kindly see. The entire document is regarding the authenticity of the letter of 22nd July. It appears from page number 165.
Where are you reading, sir?
Sorry, my lord. Page 13 of the opposition by the state. Because my lord was pleased to observe.
Page 30.
13. My lord was pleased to observe that they will produce the file and they will file an affidavit.
Regarding authenticity.
Yes, kindly see. It appears from page number 165 that the petitioner challenged the authenticity of the memo dated 22nd July 2016 issued by the district registrar Murshidabad. The district registrar has been requested with a letter dated 13th November for sending his views. Copy of the letter is at page 59, Art 17. Then my lord, kindly see. However, it may be stated that the state government time to time collect vacancy position in different districts. A copy of such report is at page 60. Kindly come to 15 and 60, 59 and 60. Kindly see, my lord.
Page
59. 59 is R17. I most respectfully submit for in attachment. This is what they have forwarded, probably. And kindly see the date of 60. This is 25th of April 2023. Sorry, my lord.
Page 59. Annexure R17.
R17. R17 does not disclose anything as to the vacancy position. Now, kindly see, my lord, page 62. That is 13. What is it? 13th of November 2024. Kindly see the last paragraph. I am directed to request you to send your views, comments in the matter of authenticity of this memo and the claim made by the petitioner herein at an early date, so that the same may be given to the learned counsel for doing the needful. So this is, they have informed to the learned district registrar. What is the answer? Kindly see the averment now, my lord. No answer. No answer as to the authenticity of this document. My lord, with all humility I submit. Whether the vacancy existed as on that date or not, my lord wanted to know that only, nothing else. And we are at duty to assist the court. They write no answer. Kindly see what they say. However, it may be stated that the state government from time to time collect, and that is page 60, kindly comes, my lord. They say that as on 15th March 2023, these people were acting, not vacant, my lord. Kindly see 19 and 20, page 61. This is the assistance they are giving.
No, page 61, where is your place, this place?
This is 15th March. They are saying as on 15th March 2023, kindly see 19 and 20. Page 61. 19 and 20, these positions are not vacant. My lord's query was not that. As on 2023, whether they were vacant or not vacant.
No, on the date when the district
Yes,
registrar...
that is 2016.
Yes.
My lord was absolutely pinpointed.
July 16.
What is the assistance being given? Nothing.
Let us see the record.
Yeah, my lord, may I just another 1 or 2 points? Let's see the records. Whatever record has come, kindly see whether they... Now, my lord, kindly see...
There should be a existing vacancy on the date when the district registrar reported to the IG.
My lord, I am saying there is no such document. This document itself is not to be believed on oath. Why I am saying
Which
so?
document?
This the 165 that on 23rd, 22nd July 2016. Why I am saying so? If from 2007,
Because of page 62 of their.
not only that, my lord. Kindly see, my lord, for 5 minutes, my lord, kindly give me, I will show the records. There is no mention of this document prior to the impugned order. Nowhere this document surfaced. There were 2 rounds of.
No, that is why the deputy secretary law has written to the district registrar.
And he is not answering. He's not. He's not answering.
They will answer. No. What is your answer, sir?
Milord, two Milord appeal of discords, which my learned senior friend is raising with your lordship. One is there was political intervention to facilitate the appointment of the private respondent as the temporary MMR in the Shia category. That is one appeal of discord. The second appeal of discord is that vacancy memo issued by the is of doubtful authenticity.
Authenticity is doubtful.
Doubtful authenticity. First is political intervention. My learned friend, Milord, senior friend, Lordship, sorry, has specifically referred to page Milord 100.
That will come as a second point.
No, Lordship, kindly, Milord, may I, Milord, because who is he? Who is he? Where does he come from?
Probably
If
he wants to
if
apply.
he is tainted with the political intervention, who is he? Lordship, kindly have a look at page 58 of my opposition.
I have not answered that, but let my learned friend finish.
Kindly comes to page 58 of my opposition, Milord. Who is he, Milord? That is the answer.
60. And who is this Muhammad Ali Sahib?
With reference to your letter, this is the same person which my learned friend was referring to, was recommended by for the appointment of private respondent at page 100. Kindly check the name, page 100. Page 100 stay application. My learned friend is referring to. I would like to recommend you the name of Arfin and Abu Sohan and Abu. 2 names, not 1 name he is referring to. For becoming
Arfin.
now, so far his appointment is that is also preceded by recommendation of the same person.
Probably not.
My God, that will allow me to place the case.
Let my learned friend, I have not
And
finished.
what is your client's name?
With reference to your letter, Akmal.
Akmal Hussain.
Yes, he is appellant with your lordship.
So therefore, he is also influential. The private respondent also.
I am not.
Question remains elsewhere. Lordship, can
finish. I will answer, my lord. Order, kindly allow me, my lord, to just 5 minutes. I submitted. First of all, my lord, the issue whether I am a political person or not was not German, but I answered that. My father was a MMR, Mohammedan Muslim registrar and a Qazi. Now, my lord, kindly see the second document in my petition. There is a notification given that if the Qazi or the Mohammedan Muslim.
No. It's not on that. You made a complaint, hue and cry with page number 100. Your client is no better off. Please accept that position.
My lord,
you also went before the minister.
No.
He also went before
my
the
lord,
minister.
may I just indicate why not? With all humility. Kindly, 100 is not one document. I will show, kindly give me 5 minutes, my lord, with all humility. Kindly see page 100, thereafter kindly see page 101. I was on 101, my lord, then my lord was pleased. Now kindly see, my lord, page 102, with all humility, 102. This is a suo motu application. Now, my lord, kindly see why it is contrary to rule 5 of the rules. Kindly come to page.
You are running away from the issue.
No. Why?
First complaint you made before against the private respondent was he took the political route. He threw a former member of parliament.
Yes.
Your client is no better. He went through a minister in charge who's a sitting minister of the state assembly.
Why, my lord? Kindly see.
Why is not the question. See, you also chose the wrong route. He also chose the wrong route. One negative, another negative.
May I just indicate one thing?
We will come to the vacancy position. That's it. Please tell.
My father was there. My father was incapacitated. Under the rule, I have a right to apply. I have applied.
Very good. Yes.
So, Miller, recommendation part over. Political intervention.
Both are recommendations.
Lordship now comes.
Because all your appointments are based on recommendations.
No,
I see.
actually, my lord, the
All your
Milord,
appointments are
no, the-
based on.
Lordship.
What about the validity?
My lord, the point, no, Lordship, regarding this
It is very,
recommend,
very important.
no, recommending part, Lordship may kindly clarify because problem lies elsewhere. If I may respectfully invite a Lordship to page, my lord, 105, my lord, of the, my lord, stay application, Lordship. 105. My lord, MMR in West Bengal is governed by an archaic act of 1876 followed by rules of
No,
1920.
no, we'll come to that later.
No,
Please.
Lordship, kindly, only, I shall, my lord, kindly see the format. Kindly see the format. That is why these people are taking advantage of these people and that people. Kindly see, my lord, page 110, clause 5 of the rule. Form of application. Lordship got this point, Lordship. How the applicants will have to, this is the format of the applications, and kindly comes to page 111. There is one clause in the form, that is clause 9, name and address the persons recommending the candidates. So this is how these people, they go to village panchayat, MLAs, MPs, Dada,
Therefore,
Didi, please give us the recommendation.
Law authorizes them to bring recommendation. All right.
Because their rights and duties are not defined in the Miller
All right.
Constitution.
Now come to the vacancy position straight.
Now vacancy, Lordship.
When-
Milord, we have taken a point. Milord, kindly, Milord, may I respectfully invite your Lordship to page 7 and 9 of my opposition, Lordship. 7 to 9, page 7 to 9. Kindly comes to page 7, Milord, clause P. Regarding creation of office of MMR in Bhaganwala, in terms of Rule 3 of the MMR Rules 1929 on the occurrence of a vacancy in the post of a Mohammedan registrar and on the creation of a new office in any district other than the district of Calcutta, the registrar shall at once make a temporary appointment to carry on the work of the office. This is the rule, subpara. Creation of office of MMR within any particular area and existence of two posts of MMRs within that area are two different matters. Milord, kindly read, Milord. Again, if I may respectfully invite your Lordship to page 105 of the stay application. The rule, Milord, kindly have a look at the rule. Page, Milord, 107 is the relevant page, Lordship. Kindly see the rule, Milord, procedure for selection of candidates for Mohammedan registrar in district other than Calcutta.
So you are trying to make a distinction between vacancy and creation.
And creation, when there is a creation, government notification.
Correspondent was
No, Lordship. This post of MMR within Bhagwangola PS was there since 1989 when the father of the petitioner was appointed. It was created then. It was created then. And what does section 3 of the Act say? Kindly see. Section 3 of the Act, what does it say?
for the purposes of this act.
Lordship.
State government may by notification official gazette.
Lord, I am handing over a copy of that. Lordship has the Act, Lordship. Act. Kindly see section 3. It says state government, it shall be lawful for the state government to grant a license
Which
to
act?
any being a,
Which act? Special Marriage Act.
no, it's an archaic act law of 1876. That's why I was willing to hand over. It does not belong to any of this, Lordship. It's an archaic act, Lordship. 1870. Kindly see the title of the act. Bengal Mohammedan Marriages and Divorce Registration in 1870. Kindly see, Miller, section 3. What does it say? It shall be lawful for the government, state government, to grant a license to any person being a Mohammedan, authorizing him to register Mohammedan marriages and divorces which have been effected within certain specified limits on application being made to him for such registration in like manner. Now, provides important. Provided that no more than 2 persons shall be licensed to exercise the said function within the same limits. So, my lord, here the jurisdiction limit is the same, Bhagwangola. There was a post in the year 1989 of the MMR. No need to create. Now, when it says there is a need for appointment of 2 persons within the same limit, then it shall be one shall be Shia and the other shall be Sunni. Within the same limit, post is there. You want to appoint 2 persons, if you can go for, but one has to be Shia, other has to be Sunni. So his father's appointment of that particular imam post within the Bhagwanwala PAs was in 1989. Gentleman died, he was appointed on probation. So since 1989, the post was there. There is no question of creating the post. So what we do is that we take the update of vacancies intermittently. So he got the vacancy position. There is a Sunni. Shia post is empty, vacant. Let us go for appointment. Now he says, next point, the moment I pass over this particular point, he says, how do you ensure that this gentleman is a Shia? My respectful answer to is that you say you are a Shia, then we should go for appointment. Sunni. You say that you are Shia. So if you are a Shia, we shall go for a Sunni. Because the state has categorically stated we do not have any mechanism to identify a person whether he's a Sunni or he's a Shia, just like Identification Act, SC/ST identification, we don't have any mechanism. We have stated in our affidavit. So what we do, we take affidavit from the concerned person. In this case, this Akmal, this Shia private respondent, he had given an affidavit that is at page 158 of the stay application. 158 of the stay application. Kindly seize, my lord. This is his self-declaration. I am a citizen of India. I, as well as my former generation, as well as my nation.
Belongs to the Sunni sect.
Now, he is Sunni. The moment we took the step to appoint another person within his area, because he was enjoying a good business in the area, so now it will get bifurcated. Because another point, kindly note, Lordship, we have stated in an affidavit, an MMR can register marriages of Sunni as well as Shia alike. If he is a Shia MMR, he can register marriage of Sunni also, because Sunni Shia marriage is not void in Muhammadan law. It is a valid marriage. So he can also, Sunni MMR can also solemnize the marriage of Shia. We have stated in our affidavit also. So now within the same limits, post was there. One was already functioning, that is my learned senior friend's client. We opted for appointing another person as Shia. Then, my lord, the entire, my lord, river Thames was set on fire. Why you are going to appoint this gentleman? How do you say that he is a Shia? Then you say you are a Sunni. If you say I am a Sunni, then we shall go for appointing a Shia. Now, my lord, appointment. In what way this gentleman was appointed? This private respondent, the Shia. My lord, Lordship has already seen, my lord, I have already shown your Lordships, my lord, page 107. Kindly come, kindly, my lord, may I respectfully invite your Lordship to page 10. What is the procedure for appointing a temporary, my lord? This MMR. There are two types of MMRs. One is temporary, another is permanent. So here temporary exercise is going on. Lordship, kindly have a look at page 108. Procedure in making a temporary appointment. In making a temporary appointment, the permanent committee need not be consulted. The district registrar shall nominate a suitable person for each vacancy. The district registrar's nomination shall be submitted to government by the Inspector General of Registration, who, if he disapproves of the district registrar's nominee, may recommend the appointment of any other candidate. A temporary license shall then be issued to the candidate approved by the local government. My lord, kindly have his procedure of appointment. We have, my lord, clearly, my lord, delineated, my lord, in our, my lord, affidavit in opposition, my lord. Kindly have a look, my lord. So his application, lordships. Milord, kindly have a start, Milord, kindly have a look, Milord, at page 38, Milord, onwards of Milord our affidavit. This is a memo from Secretary Government of West Bengal to CSR. Application of ABS for appointment as temporary MO Shia in Bhagavan Gola. I am directed to send with a copy of application dated 28 March 2017 with this enclosure received from ABS on the subject noted above for taking necessary action. So we received it, we are sending it to ICR. His application, the private respondent's application, it is dated 28 March 2017. Now, Milord, what does next page say, Milord, kindly sees? Now, CSR is sending it to the DR. From CSR to DR. With reference to above, the undersigned forwards the above noted letter along with enclosure request him to issue public notice to fill a vacancy Shia. Now kindly have a look at next page, page 40, Milord. Notice was issued accordingly. With these document credentials to be submitted by the. Now we get, Milord, prescribed format. We get 2, page 41. 2 applicants. Now, Milord, kindly have a look at, Milord, page 42. This DR, district registrar is sending the list to, Milord, the IGR. From DR to IGR. She's sending, he's sending, I would like to state, I am forwarding here with a detailed report about the 2 applications with other enclosures submitted by the concerned candidate for temporary Shia. First applicant, Arifin, second applicant, Mosharraf. Now, Milord, next page 43, from CSR to DR. What he says, the undersigned returns the above noted letter along with enclosure and request him to send the papers with specific recommendation, because the rule is that you have to recommend. Simply sending like a postman will not do. Of the 2, you recommend which one, as because 3B says his recommendation may be deferred from by the IGR. So now, Milord, kindly the DR again sends with recommendation. Page 40, Milord. Next page, 44. Now he is recommending the name of somebody. With due honor, I am resubmitting it. The application ABS Arifin. And so. In this regard, it is also said that Muhammad Mosharraf cannot submit her caste certificate from local MP so. Taking into our overall situation, I recommend the case in favor of Arifin, private respondent. Now, Milord, 45 from IGR to Joint Secretary Judicial Department, because Milord, MMR marriage issues was with the Judicial Department until 2018. But, Milord, with change of list of business as contemplated under Article 166, Milord, it went to Law Department after 2018. But this gentleman's appointment, entire thing took place before it went to Law Department. So, entire thing was done by the Judicial Department. So, they are sending a judicial, final authority. What does this say, Milord? Kindly see page 45. In sending here with a letter from DR, memo so and so, undersigned request him to approve the recommendation of DR for the temporary appointment. So, CSR is sending it to law. Now, thereafter, he gets the appointment, which my learned friend has annexed to the stay application. He gets the appointment. So, this is how the Milord, the temporary, appointment process of the private respondents was processed. And, Milord, this is one judgment where it says that, Milord, we have annexed one judgment, Milord.
Page 52.
Lordship, we have stated, Milord, that here the Shia Sunni issue was taken up at page 63.
63.
Lordship. The proposition is that procedure for temporary appointment must also comply with permanent. The procedure which you are to follow in appointing a permanent MMR shall also be followed in temporary. So this is what, Milord, kindly see page 66. By the amendment sought to be introduced in Rule 4A, through the notification dated so and so, the age qualification for a permanent appointment under 3A, when the permanent appointment require an age of 25 years, it cannot be said that authorities are at liberty to appoint a person without having such requisite age qualification to receive a permanent appointment. If such an interpretation is allowed, the person will be allowed to enjoy a temporary appointment without having requisite qualification to obtain a permanent appointment. In the same way, it says, that permanent and temporary, same criteria have to be followed. This is what it says. And, there was in this judgment also, Lordship, in this matter, there was an issue of Shia Sunni at page 52. Lordship was referring to. Here Shia Sunni issue was there. Here the Shia people came said that Sunni notification has been done. Why not for us? That was the issue in this particular judgment, in this matter. And Honorable Justice Hiranmay Bhattacharya was pleased to pass. Kindly sees page 54 is the Milord ordering.
He appeared for the petition.
Lordship, sorry, Milord. Lordship, he was.
He appeared for
I tender my unqualified apology, Lordship. Milord, page 54 is the ordering portion. Page 54. The sentence starts with, I do not, this being a position, I do not, page 54. This being the position, I do not find a reason to hold back the impugn notice is bad in law. It is evident the respondents never wanted to fill both the vacancies for the post for the area falling within the jurisdiction of the police station concerned, were granting license only to the members of the Sunni sect of community. It is rather apparent that from the very beginning, they decided to grant 2 licenses according to the provision of Section 3 of the Act. The confusion has arisen only because the selection process was initiated for granting 1 license. It is submitted that process for granting 1 license and not 2 at once was initiated for the sake of administrative convenience. Needless to say that once the vacancy meant for the members belonging to the Shia sect of the community is notified, the petitioner, if eligible, will be free to apply. For the foregoing reasons, I dispose of the writ petition recording that the respondent shall initiate the process for granting license to a member belonging to the Shia sect of the community, authorizing him to register Mohammedan and divorce for the limit specified in the license within so and so date initiated. So here it was, Milord, given a sanction that you can go for, if vacancy arises, if there is a vacancy, you can go for 2 appointments. So here, Shia people was agitating before the Honorable Court that Sunni notification was given, Shia notification was not given. My Lord, kindly see. So this judgment has taken care of vacancy position. Now, my Lord, we have categorically stated, my Lord, kindly say that no mechanism to determine or identify Shia Sunni is there. We have stated in kindly see page.
The post was sanctioned long back, in which the appellant's father was.
We have stated categorically in an affidavit. Kindly seize, my Lord, may I respectfully invite your Lordship to that relevant portion of our affidavit, Lordship. Kindly seize. Para Roman 2, Lordship.
Page 10.
Lordship.
Correct?
Lordship, it appears the state government in the judicial department appointed Aish Ahmad, that is father of the petitioner, in the year 1989. So the office of MMR area existed prior to 1989. So here, my Lord, there is, my Lord, the exercise of, my Lord.
So your case is, there is already a post which is existing prior to 1989. In the exercise of Rule 3, small a, the district registrar finds that one more person has to be appointed on temporary basis.
Vacancy, not create. Vacancy is there, one
more. So he makes the forwards application that is sent back, send it with the recommendations. He recommends this person because he has filed an affidavit. The other person has not filed an affidavit. The IG approves it. So this is got nothing to do. Your submission is this.
What my learned friend is trying to make out is that you should go for notifying the vacancy. Not it relates to creation of a post. But here the post is already in existence. Vacancies to be filled up. When was the when was the post created? In the year 1989.
Prior to 98.
Prior to 1989, where your father was appointed. So now within the same limits, Section 3 says.
He has succeeded his father.
On probation, kindly seize his paragraph. Kindly seize his paragraph, my Lord.
Suspended. On probation, my Lord, I admit, not political.
You don't want the other man to come.
No, not that. Not that. Kindly, my learned friend has finished, my Lord. May I just indicate? Kindly come to page 158. This is, he says, is the certificate on the basis of which the appointment is being made. That's what my learned friend has said. Kindly come to 235. I'll come one after the other. Why? Kindly see the aforesaid affidavit dated 17th November 2017 is not genuine. No SDM of Lalbagh for that period signed. No copy of the affidavit is available in this office. 235. This is what, who is saying, my lord? Subdivisional officer Lalbagh. There has to be a limit, my lord. My learned friend on authority, my lord, appearing for the government says.
No, 236 is a request under
235. Can you see? I'll come to that in a moment, my lord. First of all, he says this is sacrosanct because this is self-declaring document. Enough. I will not go anything more than that. But what your own department is saying, is it a genuine document? It says it's not a genuine document. There exists no such records. Kindly see, my lord, again. I've got this. The aforesaid affidavit being 1563 of 17th November 2017. Kindly see, my lord, this is 17th November.
page 158.
158, 159. Is not genuine. My lord, kindly see 1563. My lord will find from the left in 158, page 158, just after the, my lord.
Yes, please.
Yes, this document is not genuine. No SDM Lalbagh subdivision period has signed. No copies available in this office. SDM Lalbagh is empowered to sign an affidavit under section 297 of the Code of Criminal Procedure. So this is the value of that self-serving affidavit. It's all very good to say that I am political, I don't want him to come, but I must have some legal defense. Why am I fighting for? So far as this affidavit is concerned, my lord, this is the worth of it. Now, kindly see what my learned friend is saying. No question of today vacancy. A post is created, government can appoint Shia or Sunni too. But how do government knows? I have got some queries. Kindly.
No. You complete your submissions on this. According to you, this affidavit is not a genuine affidavit.
Admitted by the state of West Bengal, my lord, office of the subdivisional officer, and direction was given to initiate proceedings under 297 of the Code of Criminal Procedure.
Then what happened to that?
I don't know. I'm not a party. I'm getting this under the Right to Information Act. They are not giving us. It should have been submitted by the government. My learned friend, in all humility, my lord, submits to assist the court, saying that although this was given, this was not genuine. He has not said so. He said, just because this is given, that's the full stop. And he has referred to Rule 9. I will come to Rule 9 now, my lord. Kindly see what does MMR rule says and what is its application. Kindly see, this is the, every breach has been committed of this rule. Kindly come to page 110. And kindly come to page, my lord, 102. Kindly see.
No, you have written letters to all the authorities to cancel the appointment. Temporary. What happened to those letters?
Well, nothing. Nothing happened. That's why I came to court. And kindly see, when I came to court, how the court, well, this is order to page one. One, kindly come to the first order on this 189. The last 189 kindly comes. This is very important, my lord. The 189 kindly comes, my lord. The petitioner is aggrieved by an order dated 6 June of the District Registrar Murshidabad, appointing the private respondent as temporary Muslim marriage registrar under Rule 3B within the jurisdiction. The petitioner through learned counsel says that the appointment was made arbitrary matter on a basis of specific recommendation. Counsel also points out a communication of the joint stamp revenue on 3rd of July. Learned ASG appeared. Now I'll kindly see. Upon considering the submissions, first, whether the appointment, albeit made on temporary basis, was actually made from a Shia sect of the Mohammedan community. The subsequent documents placed before the court cast doubts on this aspect. Then, second, whether the selection process is vitiated by the intervention of several functionaries of the ruling dispensation. Both these aspects are serious and required to be revisited by the Inspector General. Then, Malad, kindly see.
Yes, direction was issued.
No, not why. Malad, kindly see one sentence. The present facts would show that the private respondent was appointed on 6th of June and the formal license was issued on 14th June. Kindly see page 191. No, this 6th June is at page, my lord. Kindly come, my lord. The 162. Kindly come to page 162. Why we are kindly come to page 162, my lord. This is the appointment and the licenses of a later date. Kindly see. In compliance with the judicial department's order, memo number so and so, in exercise of the power conferred under rule 3B of the rules, in Mushadabhi appointed the respond number 8. This is, my lord, 6th of June. And my lord, kindly see what the license is coming on 14th of June, post facto. The governor appoints on 14th of June. Prior to that, he was appointed on 6th of June. There cannot be any more breach than this. Appointment has to be made by the governor if they say the governor appointment is on 14th of June. So these aspects needs to be considered by the IGR. Now, why 2 points, my lord? First was this aspect. Second is this Shia certificate which they have given is per se, my lord. Prima facie, I am showing, my lord, even the government acknowledged this is not a genuine document. Now, if this is not
what happened after the direction was issued?
Yes, now, my lord, kindly see after the direction was issued, how IGR has dealt with these 2 points. Kindly see. This is at page 203. Has not considered this at all. Kindly see, my lord, the order is quoted. Now, 204, short case as under. On 2nd March, sorry, my lord, page 204.
But they didn't go by the affidavit. They went by the certificate issued by
Absolutely
the MLA.
MLA, and that is not there.
Page 208.
Yes.
That's what the Inspector General says.
Yes, so that's consideration was not given. And kindly see the MLA certificate. Kindly see my learned friend's affidavit, my lord, the last page of his affidavit. There is a circular which my lord learned friend has indicated. Kindly see the last page of the affidavit in opposition, page 68. These certificates will not do. My lord, kindly see, it says the department has sought for the views of monetary affairs regarding the validity. In the above,
last paragraph.
Yes.
It may be stated that there is no existing guidelines rule on.
Absolutely.
Generally, certificates issued by public representatives are considered valid.
In the absence of the administrative department may be requested to take a decision. Now, my lord, this decision is still pending. How can I rely upon a certificate of an MLA when the MP is saying I have not certified? I'm showing you one more document. Kindly see this, apart from the certificate which my learned friend has self-declaring, which has got, in my humble submission today, less value. 156, kindly see, there is a certificate by the Member of Parliament at page 156. These are the 2 documents which has been relied upon as to his authority. Kindly see page 156, page 157 is the type portion, and compare this with the document at page 246. The MP concerned has denied issuing this certificate. So this is, in my humble submission, my lord, a totally orchestrated move. Today, my learned friend is saying, I have a right to appoint Shia or Sunni. How do you know I am a Shia or Sunni? You don't know. And then you have started the process of appointing a Shia, and not the process. On a same application, you have initiated a process just to accommodate a particular person. Kindly see page 246.
Actually, this letter pad, according to him, this letterhead was issued to somebody else.
There's no, yes, sorry,
Page 246.
yes, certainly. All I'm saying, my lord, I am showing the two documents upon which they say he's a Shia are both not genuine. That's enough for me to say.
No, the member of parliament says this particular letterhead was used by him for this certificate.
Yes.
Does he say so?
Yes, he said.
246 may be noted.
Verification, please note that the above referred caste certificate has not been issued by me. What else can he say, my lord? First paragraph. He says that it has not been issued by me. Dated 7th of December 2016, that is at page 1, has not been issued by me. That's his first statement.
Where does he say so?
Yes, first, may I just read, my lord? Can you read with us? With reference to a letter dated 11th November regarding verification of the referred caste certificate dated 7th December, please note that the above caste certificate dated 7th November, a copy enclosed, has not been issued by me.
But the Inspector General refers to that certificate.
Yes, that's wrong. That is wrong. That's what I'm saying. The entire order is bad of the Inspector General because he is predetermined. I repeat. And I will show how he is predetermined. Yes, he refers to this caste certificate without considering this document. He could have come to this conclusion that this document is bad. No, my lord, I'm sorry, I've not interrupted my learned friend. Today he has changed the goalpost at all. My lord, he has totally changed. No vacancy he can show. He now says, no. Post was created in 89. I have got a right to appoint Shia or Sunni. I'm addressing that point that you cannot have an unfettered right.
This letter of the member of parliament is dated 28th of November 2023.
Yes.
The Inspector General's order is 4th of May 2023. Much prior to that, 5 months prior.
Misleading the court lordship. Simply is misleading the court lordship. So what is his problem? Why he shoe pinches?
My lord.
The lead court should go into.
Both of us cannot address. Well, let me address.
Why he shoe pinches?
My lord. My lord.
By the police authority.
My lord.
They filed the FRT last Wednesday by asking that there is no allegation proved against me and requested the court below to release me from this allegation. If you're not sure, I can produce by an affidavit.
And what do you say about the member of parliament's letter?
It is at the whose instance, my lord, can you consider at that point of time, my lord, when this order was passed, this was at the instance of the petitioner. This letter was issued. This, my lord, will find the letters and certificate issued by the and the members of the parliament.
Every document is a forge, but I have pinpointed it in my affidavit. May I just state, my lord, with documents? I don't.
Advertisement issued.
My lord, advertisement has not been issued. I have convinced that there was no vacancy.
You can't compete for this vacancy.
No. There's no vacancy. That's what I'm saying.
Lordship, may I shorten the issue?
Today,
let my learned give a declaration that I am a Shia.
No.
Before your lordship.
No.
So we shall go for a Sunni appointment.
My lord, may I indicate?
He is taking a very ticklish question with your lordship. That my appointment letter does not contain whether I am a Shia or Sunni.
No.
You say na that you are a Shia or a Sunni before this honorable court.
May I just indicate?
No, he wants to do the entire business.
My lord cannot.
No. That you after you please file.
My lord.
Ask your client to file. That's correct.
My lord, may I indicate one thing?
Very simple issue.
My lord, may I indicate?
How many rounds of litigation? How many rounds of litigation this gentleman is fighting? You can't imagine. My lord, he once upon a time challenged the virus of Section 3.
My lord, today. My lord, why is this? My lord, kindly give me a copy.
In reply, you are dealing with facts.
That's your client who was challenged.
My learned friend was there in that matter.
Not appear in the matter.
Yes. Well, which matter, I don't know. But today the situation is.
Virus of Section 3 was under challenge.
Yes. What happened?
Withdrawn.
Then why are you pointing it out? If I have
why you are
no, this kindly see. No, here my lord, kindly see how much how much unfairness. Kindly see the court's order. Kindly see. Is it recorded? It's there in the petition.
Yes, I saw.
141. Kindly see, my lord.
You challenge virus.
No. Kindly see 141 and kindly see the conduct of the state respondent.
No, we are not going on.
No, it's there. I have not suppressed that. I was suppressed.
An MMR post. Why so much? I don't know, lordship.
Because you are totally acting illegally by creating a situation where you are favoring a particular person.
What you are doing, we have reports.
Yes.
You are using emblem in your office, we have reports.
Yes, yes. But I have said state government has attempted to mislead the court, that is recorded in that order. Now, my lord, kindly see page 110. My lord, we are on the form of application. Kindly see, my lord, let my learned friend not distract the issue. Issue is, my lord, very simple here.
I
Kindly
am
see
also telling you very
110.
simple. Shia Sunni.
No, you don't have, my lord.
They appointed Shia, you say you are a Shia?
My lord, but kindly see, it's not no, you cannot appoint today. That's the point, because the application was made, kindly see 110, compare that with 102. But kindly see this document. He doesn't say what is his age, be that as it may. He doesn't, my lord, kindly see page 110. Candidates are required to submit applications form moral character. Every candidate shall be requested to furnish a certificate that, kindly see, he possesses sufficient acquaintance of Arabic language and Mohammedan law of Muslim and divorce signed by two Mohammedan gentlemen of respected position. Where is this certificate?
Changing the goal.
Where is the, my lord?
Again
This is
changing
the
the goal.
This
My
is
lord,
the goal. He has no answer. He has no answer. This initiation was entirely bad.
These are not the challenges he had.
Petitioner cannot run away from this issue.
Which-
Saying that you should first declare whether you to which sect you belong.
Sorry, my lord. I belong to a sect which they know or they don't know. But point is, how is this an application? My lord will allow this.
First of all, if you cancel his probation, matter will be settled.
Cancel it, Lordship.
Yes,
Cancel both on ground of these political appointments, if your Lordship so pleases. This MMR has become very irritating question in Bengal.
My lord, today they want to cancel that, my lord. They attempted. Why? Kindly see, my lord. They admitted my case in one paragraph.
Then the appellant will be fighting his own case.
My lord, it's not a question of if my lord's conscience is right that this is a way.
See, that's the risks are going by these letters. Actually, the member of parliament's certificate has not been relied upon. He has relied upon an MLA certificate and the Pradhan certificate.
Yes, Pradhan certificate is wrong. I will show that immediately. Kindly see. Pradhan himself is saying it's wrong. May I show that?
They are not trustworthy because you are a very powerful man. And
No, I'm not. If I
will say, come on, do that. Sir.
No, my lord, if I am powerful, my lord, I wouldn't have. My lord, has the issue raised by the court dealt with IGR? In my humble submission, no. On the short point, kindly see. Kindly see, my lord, whether the issue raised by the court of law that how can you appoint someone without the license being issued? You appoint on 6th, you issue the license on 8th of June, and subsequent document says that there are certain fraud. Whether this issue has been dealt with by IGR. If it is not, my lord, kindly set aside the IGR order. This is my humble prayer. Today, kindly see whether the IGR has dealt with the points that the learned IGR was required to deal with.
Very good. My learned
Now, my lord,
IGS order.
All right.
Kindly see his conduct. Kindly see his conduct before IGR.
This intra-court appeal by the writ petitioner is directed against order dated 30/7/2024 in WPA 23303 of 2023. In the said writ petition, the appellant had challenged a recent order passed by the Inspector General of Registration and Commissioner of Stamp Revenue, West Bengal. By the said order, the said order came to be passed pursuant to a direction issued in a writ petition, earlier writ petition filed by the appellant in WPA number 13099 of 2022. In the issue which fell for consideration before the Inspector General of Registration was with regard to the appointment of the respondent number 8 as Muslim marriage registrar within bracket MMR for Bhagwan Gola police station, whether it is in accordance with the relevant rules. The contention raised by the learned senior advocate appearing for the appellant is that the appointment of the private respondent is illegal, since no appointment, either temporary or permanent, could be made unless vacancy is declared by the government. Further, it is contended before us that a well-known leader of the ruling dispensation had recommended the appointment of the private respondent, which is illegal. Further, it is contended that the law does not provide for appointment of two MMRs within the same police station with a distinction that one would belong to Shia sect and other would belong to Sunni sect. It is further contended that it was further submitted that the appellant was appointed, when the appellant was appointed, the fact that he belonged to Sunni sect was not taken into consideration and he was appointed as MMR without there being any discrimination between sects. Therefore, it is contended with the learned senior counsel that there cannot be any distinction or difference among the Mohammedans by categorizing them as Shia or Sunni. Further, it is contended that the document showing the list of vacancies for the district of Murshidabad in respect of MMRs is a forged document and the said memo did not pertain to a declaration of vacancy. Thus, it is contended that the very appointment of the private respondent as a temporary MMR is illegal. Illegal, vitiated, and void as being contrary to the relevant rules. The learned government counsel appearing for the state submitted that Section 3 of the Act of 1876 empowers the government to appoint more than one MMR in the locality, which is a prerogative of the state. Further, the proviso under the said section states that in case of appointment of two MMRs, one must belong to Shia sect and other to the Sunni sect. Further, it is submitted for appointment on temporary basis. No declaration of vacancy is required to be made, and invitation of candidates and selection by a board is not required. And the district registrar is empowered to appoint on his own, and such appointment should be approved by the government through the Inspector General of Registration and Commissioner of Stamp Revenue. Thus, the two issues which fell for consideration before the learned court, as well as the before us, is whether the appointment of the private respondent was arbitrary, as it was pursuant to a recommendation made by a powerful person in the ruling dispensation, and whether there is any doubt as to whether, as regards to which sect of the Mohammedan community the private respondent belongs to. At this juncture, it is relevant to take note of Section 3 of the Act of the Bengal Mohammedan Marriages and Divorces Registration Act 1876. Within bracket, Bengal Act 1 of 1876. Section 3 of the said Act states that it shall be lawful for the state government to grant a license to any person being a Mohammedan, authorizing him to register Mohammedan marriages and divorces which have been effected within certain specified limits on application being made to him for such registration, and in like manner, it shall be lawful for the said state government to revoke or suspend such license. Proviso in Section 3 states that provided that no more than two persons shall be licensed to exercise the said function within the same limits, and provided further that, when two persons are so licensed to act within the same limits, the one shall be a member of Sunni and the other shall be of Shia sect. Thus, the Act makes a clear distinction with regard to cases where more than one person is to be appointed, and the proviso empowers appointing two persons, not more than two persons, and if that is done, one should belong to the Sunni sect and another should belong to the Shia sect. The refer to another rule, no, regarding temporary appointments.
The rule is at 105 of the stay application. The rule.
Where is it? 10?
105 of the stay application.
10110, I think.
105 of the stay application starts the rule. Relevant portion 107.
The government of West Bengal had issued notification dated 14th August 1929 in exercise of powers conferred under section 24 of the 1876 Act. Read with rule 2 within bracket 2 of the transferred subject within bracket temporary administration bracket close rules in supersession of all previous rules made under section 18 and 24 of the Act. Under the said rule, a procedure for selection of candidates for Mohammedan registrarship in districts other than Calcutta has been provided under Rule 3. For better appreciation, the rule is quoted here and below. So page 107 and 1087. Up to A, B, and C. Clause B of Rule 3 deals with procedure in making temporary appointments. And it states that while making temporary appointments, the permanent committee need not be consulted, and the district registrar shall nominate a suitable person for each vacancy. This nomination is then submitted to the government by the Inspector General of Registration, and if he disapproves the district registrar's nominee, may recommend the appointment of any other candidate. If temporary license shall then be issued to the candidate approved by the local government. Thus, it is to be seen as to whether this procedure had been followed by the authority. In fact, the Inspector General, while passing the recent order dated for 4/5/2023, which has impugned the petition, has noted the provisions of the Rule 3 within bracket small b. And rightly held that the rule does not put any restriction on the continuity of the functioning of a temporary MMR for a particular police station area or within a specified limit as declared by the state government. After analyzing the documents which was placed and also noting that a private respondent has produced a certificate from issued by the local representatives that belongs to the Shia sect, and also noting that the procedure under Rule 3 within bracket B of the rules has been followed, affirm the said appointment. With regard to, much has been said about the certificate obtained by the, much has been said about the recommendation letter said to have been obtained by the private respondent from a political personality, namely the president of the Murshidabad district of the ruling dispensation dated 23rd March 2017. It is pointed out by the learned advocate, counsel for the state, that the petitioner himself has also obtained one such certificate, and with such certificate was a copy of such certificate. Where did I see?
Page 58 of opposition.
The copy of such certificate has been appended to page 58 of the affidavit in opposition, which is in favor of the appellant writ petitioner, which has been issued by a minister in charge of the ruling of the government of West Bengal. It has to be seen as to why such certificates are required. The answer is contained in the rules. Yes, rules, namely Rule 5, which deals with form of application, and under clause 9 of the said rule, one of the documents to be appended to the application is the names and addresses of persons recommending the candidate. Thus, when the rule itself provides for a recommendation to be appended, nothing much can be said about the certificate obtained by the private respondent, or for that matter, the certificate obtained by the appellant writ petitioner himself. Therefore, nothing turns out on the said issue, and the same cannot, and the appointment of the private respondent cannot be set at naught on that ground. Thus, it is seen that under the scheme of the Act as well as the rules, the government is entitled to appoint 2 MMRs in a particular police station, with the condition that one should be a Shia and the other should be a Sunni. Therefore, the appellant cannot be heard to say that there cannot be any such distinction, and that when he was appointed as a MMR on probation, such distinction was not followed. When the rule mandates such a procedure, the authorities cannot be faulted for having resorted to such procedure. That apart, the learned single bench rightly noted that the government relied upon the certificate issued by a member of Legislative Assembly to satisfy itself that the respondent number 8 belonged to the Shia sect, and it is not the case of the writ petitioner, appellant writ petitioner, that he is a Shia and 2 Shias cannot be appointed. Thus, the court cannot formulate a law nor invent a new procedure in the matter of appointment of the MMRs. The appellant writ petitioner had earlier challenged the
Section 3.
Section 3 of the 1876 Act in WPA 25638 of 2017, which was dismissed as having become infructuous. However, the order did not preclude the appellant writ petitioner from challenging the selection process adopted by the state respondents. In any event, the appellant is functioning as a MMR on probation in the vacancy which was initially occupied by the appellant writ petitioner's father. Thus, there appears to be certain other vested interest on the part of the appellant writ petitioner in questioning the correctness of the appointment of respondent number 8. Thus, we find that the reasons assigned by the learned single bench for dismissing the writ petition is fully justified, and does not call for any interference. Accordingly, appeal feels dismissed. Sorry,
Milord,
sir.
may I pray for a line, Milord? Records as directed have been produced and returned. Records, Milord, as directed have been
Though in
produced
the,
and returned.
though in the earlier, though an order was passed by this court, directing the Learned Government Council to produce the records, which file is available with the Learned Government Council. In the light of the reasoning given above, the file is returned to the Learned Government Council, who in turn shall return it to the department. Yes, sir.
Lordship. Yes.
Next.
Bill number 13.
Yes.
On behalf of the respondent bank, Your Lordship.
My lord, I am appearing on behalf of respondent number 4, my.
Yes, my lord, I am for the appellant petitioner, my lord.
Hmm.
The matter is relating to the
Yes, my lord.
closing of operation of the
It is
bank
in-
joint locker
Yes, it has been.
procedure. Bank joint locker procedure. And my lord, respondent number 1, 2, 3 is the bank authority, and respondent number 4 is the private respondent with the dispute. That my lord, order impugned, firstly, the order impugned on the 15th May 2024. First word is the writ petition is expressly frivolous. Is my opinion, subject to correction of your lordship. That means no cause of action, no legal cause of action. I have annexed the application and the bank.
What happened to the matrimonial proceedings?
That is going on before the Barasat court, and previously your lordship was pleased to raise this point. We have answered. They are, he is a professor of a private college, means the respondent number 4. He is an earning lady. My lord, that's all. That is the separate cause of action. Your lordship was earlier mentioned, and please that it
Sir,
is a
in the matrimonial proceedings or in a civil proceedings, you obtain a declaration that you are also entitled to that. Bank cannot do as per their clause. It is a single
It is a joint locker,
Joint
my.
locker, Your Lordship.
joint locker.
Lordship.
And according to you, you want to delete their name and become the exclusive.
No. I am releasing. I want to release to close the operate system.
My lord,
I
according
want
to them,
to release from the system.
My lord-
Nothing but lift up from the system. It is a harassment. It is my headache. Anyway, my prayer of the writ petition. What is my prayer of writ petition? Only nothing to issue notice the parties and try to hear opportunity of being heard. May I hand over the writ petition copy, my lord? There is not there.
No. What do you want? There, it's a joint locker
Yes,
standing in the name of the appellant and the private
my lord, he is having the allegation against me that I am holding the key to the locker. But my lord, that is not true. My lord, let there be a direction to the bank that a duplicate key to the locker may be obtained.
The predicament of the bank is that Your Lord, the petitioner before the honorable single bench was submitting before the court that let there be a direction upon the bank to break open the padlock, distribute the articles kept inside between the parties. How the bank is aware?
Can't do that.
Bank can't do it. Let both the parties present. Neither her wife is coming nor husband is coming.
Bank
What the
can do is, in the presence of the bank manager,
Yes.
in the presence of both parties,
Yes, my lord.
the locker can be opened.
Yes.
Inventory can be taken.
Yes.
Put all the things.
We have
and
not
lock-
Yes,
objected.
This is my prayer, my lord. This is my prayer. This is my
After the
prayer.
inventory is taken, you go before in the matrimonial proceedings, you file an application asking for division of the articles.
Yes,
Your articles
yes.
you take, his articles.
Yes, my lord.
My-
If there is dispute, then again cause of action will do.
But the bank is
Just,
completely dark. What is
just
inside
come.
the locker? Bank is not aware.
So
What?
in your presence and his presence.
Yes,
Yes, my
yes,
The
yes,
bank will open the
Yes.
locker.
yes,
Inventory alone.
yes,
Yes, my
yes, my lord.
Photographs you can take.
Yes,
This
my.
is the banking law, my lord. This is the banking law in my hand.
My lord, another thing that is like he is not paying the key, he is not paying the money. The bank is actually trying to obtain the money from him for the locker. But since he's not paying the closure of the locker is
So
This
if
also not.
it
is
is a joint
another
account-
question.
Wait, sir. If 50/50 you have
Yeah,
to pay.
local rental also
Yes, my
are
lord,
also
yes.
dues there.
My lord,
How much is the locker due?
What's it, that I have to take
That will
instruction,
be
but
minimal only.
Yes, minimum.
let them clear because bank is
What
not
we can
standing in them.
dispose of this by saying
Yes.
yes, ma'am.
that in the locker will be opened by the bank manager in the presence of both parties. If you want, both advocates can also be present. And they will take an inventory, take photographs of the articles, put the same inside the locker.
Yes.
And that inventory list, you both of you go to the matrimonial proceedings.
Yes.
File it there and do it.
Yes, my
Yes,
lord.
ma'am.
And
This is the
subject to your lordship, indulgence
this
to your
is the
lordship.
direction of the Reserve Bank, my lord.
Also-
This is also, I have with that.
Lordship, coupled with the direction to clear the rental of the bank also, because
Yes, yes,
That
yes.
will come. First of all, their problem is bigger than your
Yes,
problem.
yes.
we have to think.
A man cannot go just without justice.
This intra-court appeal by the writ petitioner is directed against the order dated 15th May 2024 in WPA 25512 of 2023. Where is the copy of the writ petition?
Yes, my lord, copy of the writ petition.
Present
Yes,
writ
yes,
petition
yes.
was filed.
My lord.
Number 1, 2, 3.
একটা বের করে দেবো 12 পাতা
Here.
12 পেজ 12 হচ্ছে প্রেয়ার
Diptesh, give.
পেজ 12 is the prayer.
Filed for a direction for issuance of writ of mandamus to direct the respondents 2 and 3, namely the zonal manager, Indian Bank, Barasat, and branch manager, Indian Bank, Abra branch, to take steps for issuance of notice to the fourth respondent, who's the wife of the appellant, as well as the appellant, for appearance on a date fixed for taking out / releasing the contents of the bank locker, being locker number 60 capital D, key number 50, folio number 4/210. And for a further direction to the bank to identify the items which are to be handed over to the appellant as well as to the private respondents. Further direction was sought for upon the respondent bank to change the joint lock, the bank locker as from joint holder to single holder, either in the name of the appellant or in the name of the fourth respondent. The learned single bench by the impugned order dismissed the writ petition. On an earlier occasion, when the matter came up, the learned advocate appearing for the private respondent submitted that the appellant has not been paying the maintenance as ordered by the matrimonial court.
No, my lord. It is not there. That dispute is going on because he is
You
employer.
gave a demand draft.
Yeah, well, my lord, this is not the related cause of action, my lord.
No. Because of our order, you paid this money. Oh, cost. Sorry, you strike out there. We passed an order not paying maintenance. Further, we noted the learned writ court had dismissed the writ petition with cost of rupees 20,000, and we directed the appellant to pay the cost to the fourth respondent, which was complied with by issuing a demand draft in her name dated 24/9/2024. Since the parties are at loggerheads and agitating their respective case before the matrimonial court, this court is of the view that a viable solution can be interim solution can be don't say interim solution. intermediary solution can be arrived at in this writ petition, but definitely not the prayer sought for by the writ petitioner, since the respondent bank cannot identify and distribute the articles which are alleged to be kept inside the joint locker. With a view to provide an opportunity to the parties to agitate their respective rights in the matrimonial proceedings, we direct the respondents 2 and 3 to issue notice to the petitioner as well as the fourth respondent to be present on a particular day in the third respondent branch along with their authorized representatives, and the branch manager in their presence shall open the locker and an inventory of all the items shall be recorded, and photographs of the articles be taken, and thereafter the articles shall be put back into the locker, and the locker shall be locked, and the keys shall be kept in custody of the branch manager. Copy of the inventory report and photographs be handed over to the appellant as well as the fourth respondent, who shall move the matrimonial court for appropriate directions. With the above direction, the appeal stands disposed.
Let's say for the interest, for the predicament of the bank, let's say there may be a question that nothing is inside the.
The learned advocate appearing.
That is a different thing.
Respondent bank submitted that there is every possibility there are no articles in the locker. If that be so, the inventory report can state so, and a photograph of the empty locker also be taken.
Obliged.
The petition will be, the hearing will be disposed of within a time limit, my lord.
The above direction be complied with as expeditiously as possible, preferably within a period of 3 weeks from the date of receipt of the servant.
Obliged. With your lordship.
We'll stop with this.
গৌতম দা এইগুলো রিট পিটিশনের কপি লাগবে আপনাদের? লাগবে, ঠিক আছে, তাহলে পরে নিয়ে নেব।
Obliged.
আপনার
Pardon for make mention, my lord. My lord, I am from Odisha High Court, and due to some hardshipness, I am before this honorable court for mentioning, my lord. My lord, my matter is one criminal revision, and this is pending before the Honorable Justice Subhra Ghosh. Item number monthly item number 788. But today I mentioned previously also I mentioned before the court, but due to some noting there is nothing any mentioning is allowed, my lord, and due to much hardship I am before this honorable court to list this matter because my lord ex parte order passed against me of rupees 2,25,000 against the husband without go through anything, and my salary is only 40,000, my lord.
So on the administrative side, if the concerned court releases the matter, I can exercise administrative
My lord.
jurisdiction. Because all motion courts are very heavy. Our working strength is only 46, out of which 6 judges are on the circuit benches.
My lord.
So in fact, from Justice Ghosh list, some of the matters have been delinked and given to the other courts also. So what to do then?
My lord, due to outside state, I am from the Odisha High Court and totally unable to know about the procedure of this honorable court, my lord. And due to the opposite party going to pass the NBW before the trial court, then there is much more hardship from my side, my lord. That's why my lord only take up this matter or assign this matter to any other bench for listing matter.
No, assignment can be done if that court releases the matter.
My lord.
I can't pull it out of the list. You make one more request today or tomorrow. You are going back today.
My lord. That's why
When did you mention?
daily खर्चा करके आना जाना बहुत actual में very much hardship to me and my client also, my lord. That's why my lord only helped me to this situation.
But if it is not released, how can I help you? You can make one more request. You tell that you went and mentioned before court number 1, and I have asked you to make one more request.
Today at morning I mentioned before the honorable court, but honorable court totally denied to take up this matter because due to heavy burden, my lord. Due to heavy burden.
That's.
My lord.
It is not that they are not doing the matters. Every court is.
My lord, previously one illegality is against the petitioner, my lord, ex parte order.
One more attempt you make next week. You come. One more attempt you make. What is the
This is third time, my lord. I am before the Honorable Justice Subhra Ghosh, but this is not allowed by the.
What is the serial number?
My lord.
What is the
serial
number?
Number 788 monthly list.
Sir, no, please note down.
My lord, this is the petition before
you
the
give the
honorable court, my lord.
Let us see. I'll try to do something.
My lord, may kindly fix a date. पहले से हमको मतलब टिकट हम लोग को कंफर्म करना पड़ता है. Just due
All
to
right,
hardship.
let us see what can
My
be
lord.
done. Any any other advocate is with you in this?
No, my lord. No, my lord.
You have filed Wakalatnama.
My lord.
You don't have any junior who's.
No, my lord.
Then how to contact you?
My
Mobile
number. My mobile number. I just write it down.
You give your sir. Give that letter. Madam can write the mobile number. Yes.
Serial number 14.
But I am for the petition.
I appear for the status.
This is the matter,
Much
my lord.
obliged, my lord.
If Justice might recall it, my lord, sitting with Justice Bhattacharya had the occasion to deal with the matter on number of days. This is the Commission of Act of
Yes,
4.
yes, we remember.
my lord.
In the deed.
This matter has come up.
No, my lord. For the last 3-4 occasions, my lord, this private respondent again stopped appearing
This
before
is the
lordship.
matter, my lord, lordship kindly, though it is on record, my lord, 2 copies I have given order sheet. My lord, lordship kindly have a glance of my lord's order passed in the matter. How the matter, my lords took the pain to took up the matter, my lord, secured their presence through police, secured their presence. Lordship kindly sees from the first order, 1st May 2024. how the matter is dealt with.
Now, what to be done?
That
This
is
is
what
the
your,
thing,
that
Lord,
is what my
neither
lord's,
they are
my
filing
lord's
evidence.
last order of.
Problem is, how a registered instrument can be cancelled
Yes,
or.
yes, I have to answer.
That
my
is,
lord.
that
My
is the
lord has
query
seen,
put forth by my lord on 27th of November
my lord
2024.
has seen, my lord has passed an order on 1st May order, my lord has prima facie hold. Lordship kindly see his first order. Paragraph 4.
That is correct.
Yes.
100% correct.
Yes, 100%.
So you come to the 27th November order.
Then, my lord, just I'm skipping on order. Next order, my lord, how the my lord is dealing with the matter. First order, my lord's prima facie hold on the basis of paper. Admittedly, forgery has been committed. Then, my lord wanted to resolve the issue. They are not appearing. In the trial court, they did not file an affidavit. They escaped it. Before this honorable court, my lord directed them to give up an affidavit.
All right, let us assume they are not appearing at all.
Yes.
So what to be done in the matter? What is the suit which is pending?
Not suit.
No suit is
No
pending.
suit is pending. It is not nowhere related to any suit. My lord has passed an order on the basis of page 100 of the paper book. Report. Page
But
100
at
of the.
least, can you not indicate in the web portal that there is a forgery committed? Then we can ask them to file a civil suit to declare that document as null and void.
I'll come back to your lordship within 2 days, my lord, for taking instructions from the concerned authorities.
That can be done.
Whether
We
it
can
be
issue a
declared in the portal.
direction saying that a case of forgery has been committed.
Only one thing, my lord. My lord's satisfaction. I just refer certain rules, my lord. How these things has to be done, my lord. What is the duty? In such a case, my lord, I am a person. I had been to the registry office for the purpose of effecting a registration. Then what is the duty of the registry office to effect registration? এটা দেবেন জজ দুটো কপি আছে আরেকটা দিয়েছি Then lordship chapter 5. Chapter 5. Have you got lordship got it?
Chapter 5 of?
Yes, sir.
Chapter 5 of West Bengal Registration Rules 1962. B. It is the duty, it is what is conditions of admissibility. It is duly stamped or is exempt from or does not require stamp duty. Therefore, my lord, it is the condition precedent. If a person wants to get a document registered, he has to put in the correct adverbial fees assessed by the court. Here is a case, my lord. I wanted to sell a property of 88 decimal. After obtaining the certified copy, I found it has made 88. That, my lord, responsibility, first responsibility, then lordship kindly turn to 2. Next page, my lord. 21(2). On the presentation of a document.
Whether the Inspector General can inquire into the matter.
Yes.
He can. He can inquire into the matter.
He can inquire.
Then, my lord, admitted position, my lord.
Sir, departmentally they can inquire, they can find out this 88 decimal has become 99 because of act of forgery.
Yes.
Then the department can lodge a complaint, police will take action. But this document will continue to remain there. You have to go to the civil court.
Then, my lord, my submission would be before lordship subject to what from the basis of these particular provisions of law, they cannot get a document registered on below.
All right, it has been registered erroneously.
Then who will take the responsibility?
We will direct the Inspector General to inquire into the matter. He will draw a report. We will assume that report is in your favor. But how to set aside a registered instrument?
My submission would be before. Supposing a document to be properly registered, proper adverbial fees to be put in. If it is found, it is not given, it is not put in, can the document be registered? Can be said to be a valid document?
It is not a valid document.
Then, my lord, if it is not a
valid,
valid,
cancel the registration.
They will not act. They will say that it is a false document. Matter ends.
That is what my lord's first.
My lord said it is an act of forgery apparent. They are not appearing. They are not filing affidavit. Lordship, see, total document provisions of law says, my lord, how it would be scrutinized. Registration through, I have shown two provisions, my lord. Then, my lord, procedure.
Now they have not, so far as title deed 2947, they have not surrendered.
No,
But
they have
they-
not surrendered. Till date, they have not
The
surrendered.
thing, my lord, what they did, first
They came.
first document registered, then subsequently two document registered. They've made a false document affidavit before the presumption. They said that we have filed the original. When it is found,
it is not original.
It is not original.
Certified
How does this person, my lord, kindly do not allow this person to escape from my lord's court? What wrong they are doing? They are submitting a, my lord is directing to give an original document. They are producing a certified document. That's the report speaks of. They are not coming forward deliberately. When my lord has escaped them, my lord on the repeated occasion secured their presence to police. As many times police came, they appeared. The moment my lord escaped them, they are not appearing. Neither filing affidavit saying that, yes, we have executed a document. Police role, my lords, my peculiar thing, I will be showing to your lordship police's role. I have also prayed for a police. Registry office says they have lost their complaint to the police. Police says on affidavit, I will be showing. Police said of affidavit, no document is forthcoming. Ultimately, police gave a date, and where they are saying, my lord, a case has been registered against unknown persons. But where do a common people will go? They believe a registry office. They had been there.
But today they are not appearing.
Even then, lordship final person order, they will not appear.
12, 13 and 14.
They are not appearing. For the last
no
for the last three dates, my lord, they are not appearing.
What is the prayer in the writ petition? Please show the prayer.
Yes, prayer, my lord. Prayer is page 63.
63. Cancel the deed of conveyance.
And police, I also asked the police to take action. Police action.
Sir, there are two things. How can the writ court direct cancellation of a deed of?
My lord, facts are apparent before your lordship. Facts are before your lordship. My lord has hold. My lord has come to the conclusion that this is not in, this is itself is inadmissible in the eye of law because of the fact that proper stamp court fees or stamp duties, whatever, are not paid. Rule says, my lord, if it is not, scrutinization is their duty. I am referring the rules. Scrutinization is the duty. Registration of a document through system of computerization registration. Lordship kindly rule 120.
Yes.
Detailed procedure. Then, my lord, 123, determination of market value. All these things after.
So, if rule 21 has not been complied with, procedure under rule 22 has to be followed. Please come to rule 22.
On the
If any of the conditions indicated in clause so-and-so of 21 have not been complied with, or if the present refuses to pay the proper registration, the document shall be returned at once to the present with endorsement registration refused.
Refused. Then, my lord, first thing, a deed will be prepared. Then, my lord, through computerized system, they will assess the development. They assessed on 88 how they can get the document registered. 99 they cannot register. They can at best do it on 88. Then, my lord, determination of market value is
But
one
the
of the
property which was sold was only 88 decibels.
Yes.
88 decibels.
So
No, it has been already registered. But 22.
How they can get the property?
But the problem is
22
it's a clear case of fraud.
Yes, sir. Because our report also shows. On the previous occasion, my lord, I filed a report dated 20th November 2024.
27th August.
20th November 2024. That was a one-page report, my lord, I placed before your lordship.
Then, lordship, only one line I am telling. Upon satisfied self
But I have extra copies, my lord.
that the provisions of such and such as follow, registering officer shall affix the signature.
20th November 2024. Third last paragraph, on examining certified copy of deed, it appears on the schedule page that the signatures of Shri Somendra Jha and Soumitra Kumar Jha differs from the signatures on the other pages of the same deed, though it can only be confirmed by an expert agency. On further scrutiny of market value monitoring register, e-Nothikaran web portal, it is found that for plot numbers this and this, revenue had been paid for 76 decimal and 12 decimals of land, respectively, which also differs from the schedule page of the deed, indicating 86 decimal and 13 decimal of land.
99.
Now, it may be assumed that the schedule page in the deed had been swapped by fabricated page. Either at the
we
time
can
of
do one thing. Now, if you compare the original, you will be able to find out. Last paragraph. That's
but
what
they are not.
They are not. So therefore, it is presumed that forgery has been committed.
Yes.
Secondly, can now in the portal or somewhere, can you change the
That was
extent?
that was the first query put by my lord. My lord, I said, my lord, I just come back with the instructions. Can it be put in the portal or not? But IGR's portal or registration office portal.
Registration office portal, if you can do that and make the correction by passing an order referring, if he applies for a certificate copy, he will get 88 decimal document. That can be done.
Instead of 86 and 30, it will be 76 and 12. 88.
One peculiar thing. This is the first.
Sir, we are trying to explore.
Yes, I follow Miller. Only one thing I can show. This is the not a single incident in this locality. I wanted to mean it. This is not the first time that this thing happened. It is a repetition. Mass petition has been made. This particular Manikchak PS within the Malda district, it has earned a special fame. Everything is more like mass petition is there. Police role. I have prayed for a direction to police. What the police said, I will show to the affidavit. Mr. Siddiqui knows it. They say no complaint. Ultimately, case started against. They are not finding any person, unknown persons. What the common people will do?
ADSR is additional
district sub registrar.
Let him take instruction.
So in that Manikchak, this is happening.
Yes.
But this ADSR.
Lot of cases, my lord, these things are going on. In the evening, all these things are done.
We issue a direction to correct the extent of the property in your records.
In my records. But I just come back after one day, because I think, it has to be there in that, because nowadays everything is computerized. So the computerized deed would always show, my lord, that is 86 and 13 decimals.
Problem is, it is scanned and uploaded. The report says one page has been swapped. So how to remove the scanned copy and give a fresh copy? If the original is there, that can be deleted. This can be scanned and uploaded to the relevant page.
The court's order, my lord's orders, it can be done. On the face of this, on the face of injustice, it is apparent. My lord's hold. My lord can do it. Lordship, this is apparent on the face of reports. Everything says that it has been.
We can do it, sir, but modality is the issue. Now we can say this is one of the rarest of rare cases where fraud has been established beyond reasonable doubt.
Yes.
So, and the department also agrees to it. Now, what is the relief the petitioner can be granted? How can we set it not? How can we direct them to change the schedule or the extent of the property in the document which is uploaded? Or what you can do is, if you present a rectification deed, that will also require signature of both parties.
Both the parties. And I distinctly remember, my learned friend submitted on the previous occasion that it has changed hands also. He is the vendor. The purchaser has again sold some portion of the land to some other people. So illegality has percolated, in fact.
We'll issue a direction. You try and get some instructions on that.
You will also may kindly issue direction upon the IGR concerned, and my lord, as well as the registrar of assurances, 2 persons.
Which is the respondent?
IGR, I think, my lord. Respondent number 3 is the IGR.
And
Register of assurances, I has
Okay.
not been bid as a party.
Register as it is not
No,
registered.
IGR is sufficient.
IGR is enough. The register
Not valid at the IGR.
The case on hand is one of the rarest of rare cases where fraud has been established beyond reasonable doubt that to have been committed at the instance of the respondents 12 to 30, 12 to 14, 12, 13 and 14. The matter was heard on several dates and the court found that the respondents 12, 13 and 14 were not appearing despite service of notice. Therefore, direction was issued to the Manikchak police station to ensure their presence, after which they had appeared and they had changed their advocates on 2 occasions, but did not produce the original of title deed number 2947 of 2010. The district registrar Malda has filed a report dated 20/11/2024, from which it is seen there is every possibility of the schedule page in title deed number 2947 of 2010 has been swapped by fabricated page either at the time of scanning or it has been overlooked by the then ADSR Manikchak. For the purpose of ascertaining the correctness of the same, the original document has to be perused, which is not forthcoming, as the respondents 12, 13 and 14 have not produced the same despite earlier directions. Today, the respondents 12, 13 and 14 are not appearing in person or through their counsel. Thus, we are prima facie satisfied to hold that the respondents 12, 13 and 14 are defying the legal process. At this juncture, it is relevant to point out the relevant rules framed, the relevant rule in the West Bengal Registration Rules 1962. Chapter 5 of the rules deals with the procedure prior to acceptance of documents for registration. Rule 21 within bracket 1 stipulates the conditions of admissibility, and there are several conditions. Rule 22 deals with procedure in cases when the document is inadmissible if any of the conditions indicated in Rule 21 within bracket 1 within bracket C, small c, 2 within bracket HB, small h, small b within bracket. Therefore, if the correct extent of the property which has been sold was 76 decimals and 12 decimals, in all 88 decimals, the question of recording the same as 86 decimals and 13 decimals in total 99 decimals does not arise. The case on hand being a peculiar case, the court is inclined to mold the relief that the appellant would be entitled to. For which purpose, we direct the Inspector General of Registration and Commissioner of Stamp Revenue, Government of West Bengal, the third respondent, to examine the entire matter, call for necessary reports / inputs from the fourth and fifth respondent, and suggest a viable solution by which the mistake can be rectified. This court is conscious of the fact that a registered instrument is normally not interfered or set aside in a writ proceedings. But however, when the facts clearly indicate fraud and forgery being committed, the court will not be denuded of its powers in molding the relief. this court will be entitled to issue appropriate directions to the registration authority to rectify the mistake. However, the uploaded document in the website of the department has to be rectified, for which a procedure should be suggested by the Inspector General of Registration, namely the third respondent. The third respondent is directed to examine the entire issue in the above perspective and suggest a viable solution by filing a report in the form of an affidavit. Give a date after 2 weeks in the same position. Yes.
15, I appear for the respondent, my lord. My lord, on the last occasion on my lord, 6th of July 2023, my lord, this matter was taken up by your lordship, my lord. Lordship, there was a direction for filing affidavit. I apologize, my lord, affidavit, my lord, it was.
Madam, for the appellant, my lord.
It could not be filed, my lord.
But how the court can issue direction for construction of compound wall?
My lord, I am for the appellant, my lord. He is for the
I
writ
am for
petition.
the writ petition.
My lord,
If there is a law and order issue,
my lord.
Otherwise, you obtain an injunction and construct.
No, my lord,
My lord,
by
it has been
during the
constructed.
pendency of this
No, my
appeal,
lord,
my
not-
lord,
No, no, my lord, not
they-
during, not during the
they
pendency of the
they
appeal,
took
my lord.
adjournment before this honorable court and they raised construction.
No, no,
My lord, we have taken out an application can 2 for appropriate direction.
My lord, matter was taken up, your lordship, when this order, prior to that, my lord, the wall was constructed, my lord. The records are there, my lord.
My lord, on
The lordship
21st
directs
June
the state authority, state
2024,
authority has to,
2023, my lord, the matter was, they took adjournment, my lord, and the construction was put up,
No,
my
no,
lord,
the
on
construction-
25th June 2023, my lord.
Construction was, my lord, done much prior to that, my lord.
Who will appear for the state?
But Mr. Amritlal Chatterjee, my lord, appearing for the state, my lord, I have served notice, my lord.
Some thatch shed, it's not a big wall. Sir.
But my affecting my ingress and egress to my property, my lord.
I have put in, my lord, it is dark number 57, I have put in the
No, he
wall.
says his ingress is affected.
My lord.
He can, my lord, he cannot, my lord, subject to my lord, to correction, my lord. He cannot, my lord, purchase a property, my lord, hoping that, my lord, I will allow my property to be used as ingress and egress.
No,
my
my
lord.
He can't.
That cannot be
That is
done, my
not,
lord.
my lord.
There are alternative routes, my lord. There are alternative routes simply because that route is lengthy, my lord. He wants to go through my property, my lord. That cannot be done, my lord. It is my property. It is nobody's case that Dag number 57 is their property. They don't have any right over that.
But let
It
the
is
state
my
file a report,
property,
my
I
lord.
No, wait. The state won't appear. What we'll do is, you did not appear before the police because the notice returned as addressee not known.
Addressee not known.
We'll do one thing. We will direct the police to conduct a fresh inquiry. Both will be present. You produce your document, he will also produce a document. He will examine. If it is a case of trespass, if it is a case of any criminal offense being committed, he will interfere. Otherwise, he will relegate both parties to the civil court. This intra-court appeal.
My lord, kindly add that, and also the BLRO, my lord.
Yes. By the private respondent WPA 11246 of 2023 is directed against order dated 16/5/2023. The respondent filed the writ petition seeking police aid so as to enable him to construct a boundary wall. The learned writ court took note of the submission made by the learned counsel for the state that both parties were called to the police station. However, the notice served on the appellant/private respondent writ petition returned with the endorsement addressee not known. In such circumstances, the writ petitioner was permitted to construct a boundary wall in his premises within a time frame. The private respondents, the appellant/private respondent in the writ petition was permitted to assert his rights by moving the appropriate civil court. Under normal circumstances, no, don't say normal. A writ court exercising jurisdiction under Article 226 of the Constitution will not examine the title of a person to a immovable property. Furthermore, it will be very risky to allow the police authorities to earmark the boundaries or decide on who is the owner of a particular extent of land. The appellant has filed Can 2 of 2024, contending that during the pendency of this appeal, the respondent writ petitioner had constructed the boundary wall. This allegation is denied by the learned advocate appearing for the respondent writ petitioner, stating that the boundary wall was in existence much prior and the wall is within the property owned by the private respondent writ petitioner. In any event, the police can inquire into the issue as to whether any cognizable offense has been committed or an act of trespass has been committed. To that extent, the police will have jurisdiction. Since the appellants did not appear before the police authorities, we deem it appropriate to give one more opportunity to the appellant to do so, making it clear that the police cannot decide the question of title to a property, but they can examine the limited issue as to whether there is any trespass committed or whether the right of ingress and egress of the appellant appellant is affected on account of the boundary wall said to have been constructed by the respondent writ petitioner. Accordingly, the appeal stands disposed of by directing the third respondent police to issue notice to the respondents, to the appellant as well as the seventh and eighth respondent, and also request the fourth respondent to depute one of his officers with the concerned land records and in their presence inquire into the matter, and if any cognizable offense is made out, then proceed to take action in accordance with law. The above direction be complied with within a period of from the date of receipt.
One thing, instead of respondent number 3 made be respondent number 2, since the respondent number 3 is acting hands in glove with the writ petition.
All right, respondent number 2. Next.
And the one liberty, if it is there is dispute, I shall approach before the civil court.
Needless to state that if there is any dispute with regard to the title, either of the parties are at liberty to assert their rights before the appropriate civil court.
Great. And the civil court will verify the claim independently because this order may not be used.
In the event the matter goes before the civil court, no, you strike out. Needless to state, in the event the parties approach the civil court will decide the matter independently based on the oral and documentary evidence placed before it, uninfluenced by any observations made by this court or by the learned writ court or in the police report.
Yes, my lord.
Next.
Serial number 16 and 17.
I'm appealing for the respondent number 1.
My lord, I am appealing for the appellant in this matter, my lord. My lord, on the last occasion, lordship was directed to serve, my lord. I have already served.
What is the matter you tell?
My lord, I'm praying liberty to file the affidavit in opposition to their application, my lord, as because they have not annexed the writ petition.
My lord, because my lord, we have not made party in the writ petition, my lord.
And they have
and more so, my lord, we have filed 2 appeals, my lord. In one appeal, my lord, we have challenged the order dated, my lord. February 26th, 2021, my lord.
Yes, that
and in the second appeal, my lord, there was a liberty by the honorable single judge, my lord. If your lordship kindly takes page 95, my lord, in the second appeal, my lord. That is, my lord, MAC number 1176 of 2023, my lord. In that, my lord, 12th May 2023, my lord. If your lordship kindly peruse.
What was the writ petition for, sir?
This is
the lordship, the writ petition was for the tender was floated, my lord. We have participated. We were the successful bidder, my lord, and they have filed a writ petition, my lord, where they have not made us the party, my lord, challenging the my lord tender process, my lord.
And what happened to the writ petition? Allowed?
My lord, writ petition allowed, my lord. Interim order passed, my lord, without hearing us, my lord. And your lordship, liberty was given to us, my lord, to file appeal against, my lord, against the, my lord.
No. See, the impugned order is dated 12th May.
My lord.
What is Can 6 of 2023?
My lord, Can 6 is more for the addition of party, my lord. We would try because they have not made us party in the writ petition, my lord.
Actually, my lord,
we tried to be added in the writ petition, my lord, but that was rejected, my lord.
the applications pending before the single judge, my lord, has not been annexed before.
Where is
How
the
would I annex?
My lord, writ petition is with me, my lord,
Pending,
but
my
that is
lord. It
not
is
before.
pending. Yes, my lord. It
Yes,
is
writ
pending.
petition is.
What is the interim order?
My lord,
My lord,
interim order was passed on, my lord, that is on the order dated, my lord.
My lord, it is 26th of February 2021, my lord. It is in mat number 959 of 2023, my lord. That is item number 16, my lord.
That is in mat number 959, page number 91 is the order impugned which they have challenged.
What is the tender for?
This is
My
a
lord,
tender
it is for the
cook that
catering
supply in
service,
a
my lord.
mental hospital.
Catering service floated by the chief medical
And
officer.
my lord, there is actually there.
You are the existing supplier.
Yes. And my lord, there is a covenant of the contract which was earlier challenged before the single.
All right, we can do one thing.
My lord.
Interim order is operating from 2021.
My lord.
We cannot vary that now. We will allow Can 6.
My lord.
You will make him a party in the writ petition.
My
You file your affidavit in opposition. Seek for vacating the interim order.
My lord. But
They
my
have
lord,
already sought it, my lord. That is the order dated 26th February, my lord, being page 91, at page 91 of the mat number, my lord, that is 9. Mat number, my lord, 9, mat number, my lord, 959 of 2023.
my lord, if your lordship kindly comes to page 98, my lord, of the appeal, my lord, of the stay application, my lord. 98.
Lord, there is a division bench order and
My lord,
the
may I,
judgment
your
was.
lordship? Your lordship, page number 98, my lord. Of the mat, my lord, mat 1176 of 2023, my lord.
দুটো ম্যাট একসঙ্গে বলছো কেন?
Yes, page 98.
Confused করে দিচ্ছি।
কোন ম্যাটটা আগে ধরলে?
If your lordship kindly comes to, my lord, second last para, my lord.
See.
My lord. There is a liberty by the single bench, my lord, to prefer an appeal, my lord. And we have preferred the appeal, my lord, upon the direction, my lord, upon the liberty given by the single bench, my lord. Because there, my lord, our contention was not, my lord, allowed, my lord, because, my lord, they have not made us party in the writ petition, my lord. We tried to be added, my lord, but that was rejected by giving us liberty to file the appeal, my lord. Page 98, my lord.
See, he is admittedly a successful bidder.
Yes, my lord.
No. That
Yes,
is
my
not
lord.
the case, my lord. That is the reason, my lord, the writ petition is required to be gone in.
My lord, even the single
Writ
bench has
petition
recorded
case
this, my lord. The learned single bench has recorded this, that I am a successful bidder, my lord, of the tender floated by the chief
Applicant
medical
claims
officer.
to be a successful bidder.
Yes,
that
my
has
lord.
been
Yes.
No.
been challenged.
Yes, claim of the successful bidder has been challenged, my lord. But the thing is that, my lord, kindly read the, my lord, the.
No, if he has been a successful bidder,
My lord.
you have challenged it in WPA 3965.
My lord,
Is he not a
my
necessary
lord,
part?
kindly consider, my lord, your lordship is required to look into my writ petition. Why?
Sure.
Yeah.
My lord, that I am to show you, my lord, because I have the contempt application, my lord, only single page, my lord.
You show the writ petition, sir.
Yes. The writ petition was filed before the opening of the tender procedure. And it was filed to enforcement in the annexure P8, my lord, where there is an order that the particular condition of the contract is required to be modified.
My lord, even he is not the candidate of the Purulia, my lord. He is the candidate of Asansol, my lord. He has not.
No.
He has not fulfilled the criteria, my lord.
It's a contempt application. My lord, kindly
But
give.
that has not been
7
agitated.
days, my lord, I shall come up with the writ petition.
Mandamus, particularly 12th respondent,
My
to rescind recall the e-tender
E-tender,
dated
yes.
21/1/2021.
Yes.
For supply of cooked diet
Yes.
at Institute of Mental Care, Purulia. That is the prayer.
Yes.
You are a participant in the tender.
I have not participated. I was the existing tenderer, my lord. I have challenged the condition of the particular
How
tender.
can you?
My lord.
What is your locus standi?
My lord, that is the order passed by the division bench, my lord. And that was the consent order, my lord.
My lord, they have submitted incorrect submission before the single bench, my lord, and had obtained the order, my lord, from the single bench, my lord. They were not even the participant in that tender, my lord. Despite that, they have challenged this, my lord, writ petition.
And the particular tender was open when the interim order was carrying on, my lord, continuing.
So therefore, he is all the more necessary.
Yes, let him,
He will be implemented. See, according to you, in MAT 1970 of 2017,
yes,
a direction was given to issue fresh corrigendum by retaining clause A and B in the corrigendum. That was not done.
that was not done. That is the reason this writ petition was filed, and that was filed before opening of the bid.
Yeah, okay. Wait. Please come, sir. Now, MAT 1176 of 2023, this appeal, the separate order, sir. This appeal has been filed challenging the order dated 12th May 2023 in Can 6 of 2023, arising out of WPA number 3965 of 2021. The said application was filed for addition of party, namely the appellant to be implemented as a respondent in WPA 3965 of 2021. It is not in dispute that the appellant participated in the tender and has been successful in the tender process. The writ petitioner has filed the writ petition to rescind the tender notice for certain reasons. Therefore, we are of the view that for effective and proper adjudication of the writ petition, the appellant will be a proper and necessary party to the writ petition. For such reason, MAT 1176 of 2023 is allowed. Consequently, the order passed in Can 6 of 2023 is dated 12th May 2023 is set aside, and Can 6 of 2023 is allowed, and the appellant is directed to be added as a respondent in the writ petition. Necessary correction be effected in the cost item. Then what is the other Can?
Other Can is challenging the order dated 26th February 2020. My lord, that is the order passed. Interim order.
My lord, that is for the vacating of the application.
All right. The MAT 959 of 2023 has been filed by the challenging an interim order dated 26/2/2021 passed in WPA 3965 of 2021. Though the said application was considered and the court refused to entertain the prayer. It is seen that the interim order has been in operation since 26/2/2021, and to modify or vacate the same at this juncture will not be an equitable proposition. Since we have allowed MAT 1176 of 2023 and added the appellant as a respondent in the writ petition, the respondent will have an opportunity to file their affidavit in opposition in the writ petition so that the matter can be finally heard and disposed of. Accordingly, this appeal is disposed of without interfering with the interim order granted on 26/2/2021, but giving liberty to the appellant, who is the newly added respondent in WPA 3965 of 2021, to file their affidavit in opposition within 3 weeks from the date of receipt of the server copy of this order. Reply, if any, within a week thereafter. Let the writ petition be listed before the appropriate bench in the monthly list of April 2020.
My lord, one indulgence, my lord. My lord, in the meantime, my lord, some protection be given, my lord, because the authorities, my lord, continuously asking for the keys, my lord.
Which keys?
My lord, they are holding the key
because
of
we
the
are the
storeroom, my lord.
You give the keys.
My lord,
Otherwise, patients will suffer.
My lord,
you give the keys.
My lord, then, my lord, no action be taken, my lord, no new tender be floated, my lord, in the meantime, my lord. Kindly, my lord, that protection be, my lord.
You surrender the key, otherwise we will give the direction. The appellant is directed to surrender the keys of the storeroom to the officials of the respondent hospital. Next.
Grateful, my lord.
Deeply obliged, my lord.
Serial number 18.
Grateful.
But I am for the respondent, my lord, opposite party. Whereas, my lord, this appeal, my lord, has become infructuous. If you look
Learned
at this,
advocate for the appellant submitted.
my lord, I am for the respondent.
Oh, no.
And I am for the respondent, my lord.
Why it has become infructuous?
This, my lord, kindly see their prayers, my lord. Prayers in the appeal, my lord, at page 34, my lord.
32.
Yes, my lord. They have asked, my lord, that we should not issue work order, my lord. And my lord, we should not issue, we should declare them as a successful bidder, my lord. My lord, their tender was cancelled, my lord, by the tender committee, my lord, on two grounds, my lord. One, my lord, the false declaration, and second, improper documents. Now, challenging that, they came before this honorable writ court, my lord. Honorable writ court refused to grant any interim order, my lord. Challenging that there before your lordship. Now, my lord, this work order was issued, my lord, on 29 September 2023. I have work order with me. And my lord, they filed appeal on 3rd October 2023. They filed appeal on 3rd October 2023. Thereafter, my lord, this LOA was issued, my lord, 29 September 2023. My lord, the appeal was filed on 3rd October 2023. And thereafter, my lord, this work order was issued on 29/11/2023.
Now the work has been commenced.
Yes, comments and it's going on, my lord. And my lord, your lordship knows, my lord, 41A, my lord, specifically fact, my lord, tender matter, HA, my lord, tender matter, my lord, your lordship will not pass any injunction order, my lord. I am also brought my NG.
Now what did the learned single bench do?
The learned single bench, kindly see the interim order, my lord. The learned single bench find that there is no prima facie case to give injunction, my lord. Kindly comes to, my lord, page 212, my lord, of the stay application 211.
This intra-court appeal is directed against a refusal of an interim order in WPA 22714 of 2023, which was filed by the appellant writ petitioner. The learned writ court, after considering the facts of the case, prima facie found that the appellant writ petitioner has not made out any grounds for grant of stay of the e-tender process. The matter, this appeal had been was in the list of this court since October 2023, and on 3 occasions adjournment was sought for at the instance of the learned counsel for the appellant. Today, none appears for the appellant. The learned advocate appearing for the respondent Eastern Coalfield submitted that work order has already been issued and the successful tenderer has commenced the work in question. Copy of the work order along with the connected communication has been placed before this court, which is taken on record. In the light of the same, we find no grounds to interfere with the impugned order. Appeal dismissed.
Yep.
Next. Serial number 19. Oh, no.
My lord, I am appearing for the state respondent led by Mr. Amal Kumar Sen, my lord. The brief is lying with him, my lord.
All these matters, they are not at all interested from when they are taking adjournment since February 2023. None appears for the appellant. Even on the last occasion, that is on 10/7/2024, none appeared for the appellant. So and so appears for the respondent state. Thus, the appeal dismissed for non-prosecution. Next.
Serial number 20.
petitioner.
I appear for the other respondent, private parties.
Report number 9 and 10, we are appealing.
Lord, I appear on behalf of the appellant. Now, my lord, this is an issue where my lords will be pleased to find that, my lord,
लिखिए बताओ लिखिए दीजिए
my lord, the only issue which is required to be decided in this matter is that whether I have a right to repair or reinstall camera at the same place where it was installed. Now it appears, my lord, that on the first occasion, a writ petition was filed. My lord, an order was passed that my lords will be pleased to find at page 48. Just I will be showing to placing before my lords 3 orders, and then I leave it to my lords. 48 is the first order, 17 July 2019. My lord, there was a direction of this court that petitioner has a right of security, the private respondent has a right of privacy. In the facts of the present case, installation of a camera at the common passage over which the petitioner.
So liberty was granted to install.
Yes,
But
I'm
you
grateful.
Mala 10 CCTV
Then-
camera has been installed in
Wait,
my home.
wait. Then what happened?
Then, my lord, a second writ petition was filed. That second writ petition, my lord, that my lords will be pleased to find at page 56 to 58. There, my lord, the issue was with regard to the replacement of an existing CCTV.
Why do you require 10 cameras?
My lord, what is happening, I tell you, lordship, this is this is commercial and my lord, residential also. Now, my lord, when it is not working, there is requirement of particular, my lord, replacement, or sometimes it is required that a new fresh camera be installed. Now, my lord, this is a thing.
Oh, you filed the third writ petition for what relief?
Yes, my lord, I'm grateful to my lords. My lord, kindly see, your lordship has noted, my lord, the second writ petition that the order that directing the authorities to ensure that no occurrence of any breach of peace at page 58. A breach of peace.
Intends to replace the existing?
Yes.
Install those damaged in the meantime.
Yes. Now, why the third writ petition was done? This particular, after this repair, my lord, it appears, my lord, that the particular private respondent, he damaged the CCTV. Now, I am an aged person, my lord, staying there alone. I have my right of security.
Now, police have registered a case.
Kindly see, my lord, your lordship may kindly consider this order, my lord, that page 56 to 58. Now, my lord, the learned court below, my lord, that my lord had noted, my lord, I am sorry to say, my lord, that my lord, I will be, I have to avail of my remedies before the competent civil court. Now, I say, my lord, that this has got no particular semblance of any particular, my lord, a particular.
Sir, we do not know what is the resolution of the camera. Sometimes such a small camera can have a very wide coverage. It may even focus on his window or his door, etc. Now, out of 10 cameras, 4 are damaged. So, no civil court matter is pending?
No, civil court matter is this is a certified copy of the order.
I have brought it. Kindly see that.
This is not a certified copy of the order, Malad, regarding acting court. Malad, I will keep a one copy of this, Malad. Can you pay apology, Malad?
Apology. Apology will not become one more copy.
Civil court idiot.
And a civil court suit is proceeding, but 2 proceedings has been filed by the
eviction.
And they have been filed by the 2 citizens and that has been dropped by the that on non-prosecution for their ground. They have the phrase proceeding has been pending before the trial court.
There is eviction suit.
What is the suit for?
Suit for my lord declaration and the common passage. That is my lord dispute relating to the common passage.
Kindly see.
This camera has been used for the my lord the purpose of the common path.
6 cameras are working.
Yes.
Be happy with that.
My lord, this your lordship may kindly consider that particularly.
If we were sitting in a division bench, we will revise the earlier orders.
No, I can.
The learned court, while saying it has also made an observation, while his right of privacy may be
Right,
affected.
that is my wife is a school teacher. My lord, he cannot go into the roof also. This camera has been installed by the senior citizen. Such a place that we my lord the right of privacy.
By the writ petitioner is directed against.
There
the
are only
order
one
dated
thing
so and so.
before your lordship passes an order.
No, we'll make it clear. Order dated
No,
31/2023.
your lordship may kindly, my lord, permit me one thing, my lord. I just appeal to my.
No, this is too much, sir.
I say,
58,
my lord,
5,
that
58 of.
the other owners of the building, they have not raised any objection. Now, my lord.
Probably they are so afraid of your client, Mr. Tanmoj, Ms.
No, I
Kalita.
submit to my lords, my lord, I submit to my lords, my lord.
Dated so and so, so and so.
That
This is third writ petition filed by the appellant for the very same purpose. For more or less the same purpose. In the 2 earlier writ petitions, permissions were granted for installation of 10 CCTV cameras as well as for repair of the damaged cameras. The third writ petition was filed alleging that the private respondent have damaged 4 cameras. As observed by the learned single bench, definitely it will affect the right of privacy of not only the private respondent, but the other persons who may be residing in the building or using the building for commercial purposes. Therefore, we are of the view that the learned single bench was fully justified in dismissing the writ petition. Furthermore, we note that there is a civil suit pending between the parties in TS number 77 of 2014 on the file of the Civil Judge Junior Division, First Court, Bariapur, South 24 Parganas. So, hence we find which is a suit for declaration and permanent injunction in respect of the common passage. Therefore, we find no grounds to interfere with the impugned order. Accordingly, appeal is dismissed. However, considering the fact that the appellant is a senior citizen, the cost imposed on the appellant is deleted. Next.
Bill number 21.
My lord, take back the copy of the order.
21.
Should I appear on behalf of WPACTCL in this matter?
Yes, sir. Mr. Demanjan Mukherjee, what is this?
But I beg to appear on behalf of the private respondent party.
Who's for the appellant? What is this matter, Mr. Mukherjee?
Well, in respect of a domestic application for domestic connection,
Enjoying domestic electricity service commission, disputed property.
we granted him the connection and subsequent to objection being raised in respect of an order passed by the learned civil court, my lord. We asked him to produce certain documents and a various petitions. So he failed to do it, and we upon notice we disconnected. Subsequently, he came up before this honorable court in the single bench, my lord. The single bench was pleased to direct us to reconnect the supply, my lord. We have reconnected it, and the respondent who was there in the writ petition, private respondent, has preferred this appeal.
What is the stage of the civil suit?
That we are not a party, my lord, we cannot say, my lord. But the order has been complied with.
All right. None appears for the appellant, so and so appears for the respondent. Give a date after 2 weeks, sir, in the same caption.
Last occasion also. On the last occasion also, if I am not wrong, my lord, they were not there.
They are not present.
If I am not wrong, my lord,
All
subject to
right.
correct.
None appears for the appellant. No, the appellant is not represented today. No, last time they took adjournment.
As you like.
Then you adjourn it by 2. None appears for the appellant. 2 weeks. Next.
number 22 and 23.
No, my lord, 22 and 23, I'm praying for Lord TC on behalf of the appellant.
Why? It won't reach, sir, then.
My lord, I am not in this matter. I am instructed to one of the adjournment.
Item number 22, Your Lordship, Mr. Aniruddha Chatterjee is appearing for the respondent, Your Lordship. He has left the court due to some personal inconvenience. Let it be, my lord, if to be adjourned.
All right. As requested by the learned advocates on either side, adjourned by 3 weeks. Next.
Serial number 24.
I am for the appellant, my lord.
Hmm.
My lord, only the part of the judgment dated, my lord, 24th of January, my lord, I am dated by Mr. Chatterjee.
My lord, this case has a short history, my lord. What happened in this case? On 27th of February 2017, the husband of the appellant was called on before the Shithi police station by two uniformed constables to meet respondent number 4 of the petitioner immediately. Respondent number 4 is a lady sub-inspector. The husband of the present appellant, he rushed to the Shithi police station, wherein the respondent number 4 of the said police station started interrogating him, and suddenly she was so abusive, so rude. He faced a heart attack and he fell down in the police station, and thereafter he died. He was taken to the hospital and thereafter he died. My lord, I have preferred a writ application, my lord, before this honorable court. Kindly comes to the main order portion. I'm not reading the entire portion, only kindly comes to page 16 onwards. The honorable single bench admitted that there was something. My lord, initially I lodged a complaint under section 302, but my lord, case was not started under section 302. Subsequently, they were the final report was given and they were discharged. Right? They were discharged. No, acquitted. Ultimately, they were acquitted. But my lord, the honorable single bench, if your lordship kindly comes to the inner page 16, paragraph 34 onwards. Fourth respondent, I'm reading from my lord, paragraph 34. Shall I read, my lord?
No, ultimately, which portion of the order is against the?
Yes, my lord. From paragraph 34, thereafter 35, the honorable single judge admitted that it appears to this court that the police authorities have proceeded to act in a manner so as to hide the real facts from the court rather than to unearth the real truth. I have read from page 35. Thereafter, my lord, kindly comes to inner page 19. The honorable single bench passed an order from page 41. The writ petition as well as any other petition documents etc. filed by the petitioner along with a copy of the judgment be forwarded to the registry to the court of the learned additional chief judicial magistrate Shialda, who upon receipt of the said material shall register a complaint under section 200 of the code on the basis of the allegations contained in the petition. My lord, nothing happened. They were acquitted from the court below, my lord. Neither any case was started under section 302. They were simply acquitted.
No. What happened? They have not. The matter didn't go to the court.
Matter went to the court. A case started under section 304.
No. It was directed to be registered as a private complaint.
Yes. Thereafter did not go to the court.
Why?
I do not know, my lord.
File a contempt. Why are you filing an appeal?
No, that is one aspect of the matter, my lord.
Why are you filing an appeal?
My lord.
You want CBI to investigate?
No, my lord. We have preferred for compensation, my lord. Compensation, because my lord, death was done into the police station, inside the police station.
That has to be ascertained. That is still, if suppose these fellows have been acquitted, where is the question of this lady constable being acquitted? Where is the question of payment of If according to you, the direction has been violated, please file a contempt petition. And so far as compensation is concerned, that will be subject to the outcome of the criminal proceedings. As of now, zero compensation if they have acquitted.
My lord, they were acquitted. Case was not started. Even the order passed by the honorable single bench, nothing was done.
Probably by the time this order reached, they would all.
No, my lord. Subsequently, they were acquitted.
Then you file a.
Subsequently.
Where is the prayer in the writ petition?
Liberty theatre. My lord, if liberty may be. Oh, writ petition, my lord. It was initially not annexed. Subsequently, we have preferred the supplementary affidavit.
Dereliction on the part of the police authorities are in the observation admitted.
The Honorable Single Judge admitted that the conduct of the police station is not good and not according to the law.
This lady officer is from which police station?
Shithi police station, Shithi.
Where is that?
Shithi police station is in, no, not Calcutta or Central Calcutta, Shithi police station. তাই তো সেন্ট্রাল ক্যালকাটা
একটু বোরানগর যাবার আগে তো
টালা ব্রিজের পরে
ওই টালা ব্রিজের পরে
টালা ব্রিজ রাইট আফটার টালা
এই ফাঁকা থেকে
পেজ 23 এটা কোথাকার পেজ 23
এই জাজমেন্ট
হুম
চিঠি পুলিশ
আমারটা তো তখন মার্ক করা নেই ওটা তো মার্ক করা তো নেই আমার তুমি কোনটা দেখাচ্ছ
স্টে অ্যাপ্লিকেশনটা
Officer, come to any adverse notice in any other matter?
My lord, I will have to take instruction.
My lord, regarding Shithi police station, there are other allegations that I know.
So concerning this RG card,
This particular,
Concerning the Arjikor Mole Shithi, na, she's a Tala. That is from of Tala police station. Arjikor is of Tala police station. Regarding Shithi, there are other allegations, my lord. In Shithi police station, another person, he was also died inside Shithi police station, that I know. Initially, I was appearing in that matter. That is also against Shithi police station.
আপনি যেটা প্লেস করেছেন 1832
35
35 single serious dereliction and violation of the Supreme Court's order.
My lord, if your lordship kindly comes to page 18 once, sorry, paragraph 18 once, my lord, of the Honorable Single Bench's order. I am reading, my lord, loudly. In view of the observations made herein before, this court is of the considered view that the respondent police authority, while calling the husband of the petitioner to attend the police station, has acted in gross violation of the provisions of the code and also the direction in Lalita Kumari Supra. This court accordingly holds that Article 21 has been violated in the case on hand.
this intra-court appeal by the writ petitioner is directed against the judgment dated 24/1/2023. After hearing the learned senior advocate appearing for the appellant and the learned government counsel, we are at a loss to understand as to why the appellant has filed the instant appeal, since all the findings, observations, and ultimate conclusion is inures wholly in favor of the appellant writ petitioner. The learned senior counsel senior advocate appearing for the appellant submitted that the directions issued by the learned writ court has not been complied with. If that be the case, then the remedy which is available to the appellant is under the Contempt of Courts Act and not by way of an intra-court appeal. Therefore, the appeal stands disposed of, leaving it open to the appellant to initiate appropriate proceedings in accordance with law if they allege that the directions have been violated.
Liberty given, my lord.
Yes.
Grateful, my lord.
Next.
Grateful.
Serial number 25.
আমাদের 26 আছে তো মিডল্যান্ড এই মিডল্যান্ডেরটা দে মিডল্যান্ড That's the understanding. When it is good. 26.
My lord, item number 24, I'm led by Mr. Joy Shah. 20, I'm sorry, my lord, item number 25.
25.
My lord, for the petition, for the appellants, my lord, I'm led by Mr. Joy Shah, was praying for a not today,
Last
my lord.
time, senior mentioned that they want to file a compilation. Where is
Yes,
your?
yes, my lord. My lord, it's been prepared. My instruction from the advocate on record is that it's been prepared. Due to some difficulty, my lord, he's not been able to log
Where
in.
is the compilation, sir?
My lord, could I just file it on the next day, my lord?
No,
Lordship,
no.
adjourns it for one day, kindly.
It won't reach. Don't mention. Huh? If you're not able to utilize the opportunity when the matter reaches, please don't mention for upgradation.
I
The
apologize, my lord.
adjournment is sought for on behalf of the appellant. 2 weeks.
Number 26.
This is my appeal, my lord. I'm being led by Mr. Shomo Mojumdar. May I get a not today?
No, not
My lord.
today. You can argue.
No, no, my lord, I'll be very honest. This has a technical question of law on the definition of change of management rules. My lord was pleased to ask us to submit submit a chart of what could be payable if the matter could be settled. We had done this. The other side possibly doesn't want to settle. So now it has come back after some time.
Where is the chart?
My lord, that is not a part of the petition. That was prepared by us later.
Opposition.
No, no, opposition has been served on us. Also, the reply has to be filed. My lord, kindly gives us just, kindly gives us just 1 week.
Subject to correction.
Kindly just gives us 1 week. We'll come. Kindly gives us just 1 week. 1 week, we'll come back, my lord.
No. This is that.
That change of management, my lord.
Yes.
Yes.
Nobody in the state is challenging it except you.
No, I'm not challenging the change of management rules. I'm just saying that it has to be read in a certain manner. That's it.
A very detailed order, sir.
No, if my lord.
No. In fact, we heard Mr. Mazmundar.
No. We did not make our submissions.
No, definitely.
No. We did not, my lord. We did not. My lord, we did not make our submissions. There was indications as to what the dispute is all about, but we did not really go into the matter because it had fallen from the bench that let us make up, because I'll tell you, my lord's observation is that we will also have to survive and the state will also have to earn its revenue, which is why we made that chart, which I'm not sure if my advocate on record is here. We'll have to, but we had shared it with the other side. We have to file the reply. Kindly gives us 1 week and gives peremptory directions. If Mr. Mojumdar is not here, I'll argue. Kindly gives us 1 week.
So as of now, you don't have a license.
No, as of now. So that is also a part of the order. There is a license.
And he's got a very big criminal track record.
No, it's not. But there are technical arguments that have to be made.
Right. The appeal is admitted for hearing. Prayer for stay refused. Next.
Number 27.
Lordship, I appear for the appellant in this matter. Lordship, the matter is for hearing today, Your Lordship.
My lords, may I pray for an adjournment? I'm being led by Mr. Shobhushaji Chaudhary in this matter. Yeah, my leader is here.
Your Lordship, I would like to come physically to do the matter, Your Lordship. Due to a personal difficulty, I was not able to make it, Your Lordship, today.
Now, lookout circular has been quashed.
There's a condemnation.
All right, it has to be heard, madam. It can't
Yes.
be under the adjourned admission category. It can't come.
I understand, Your Lordship, but I'm humbly praying if this can be passed over, Your Lordship, or if a very short date can be given.
Then what will happen to the other adjourned motions? Never reach.
Your Lordship, I understand, Your Lordship, but the thing is that I do not have the copy of the brief with
Yes,
me, Your
we'll
Lordship.
fix a date. The writ
Yes,
petition was filed challenging a lookout notice issued by the appellant bank, which has been quashed by the learned single bench by a detailed judgment dated 31/1/2023. The correctness of the decision taken is being challenged by the bank in this appeal. Therefore, the appeal has to be heard. And the question of granting an interim order stay of the judgment would not arise. Accordingly, application for stay is rejected. Appeal is admitted for hearing. Next.
Serial number 28.
My lord, I am appearing on behalf of the state, my lord.
I am for the appellant.
I am appearing.
You condone the delay.
That your lordships were pleased to consider this matter on an earlier occasion.
Number 3, complainant. Mother of a victim. By your lordship heard this matter on 29th of August 2023. There was a thorough order. My lord, kindly recollect the mother of a boy. She has come before this honorable court where the boy was died during COVID on the footpath. Allegation was against Midland Nursing Home.
Let us, my lord, correct my learned friend, my lord. Firstly, he didn't die on a footpath. And secondly, he didn't die because of me.
Yes,
he died because of a government hospital.
No.
Not at all, my lord. This is a wrong submission before your lordship. Yes, I hospital referred to a nursing home, my lord.
Yes.
Even the patient was not a COVID patient at all.
Lord, may I place the facts, my lord?
COVID was declared by Midland Nursing Home. Actually, he did not die due to COVID. He did not die due to COVID,
Lord,
but that was declared by him that he died due to COVID.
Was 10th of July 2020. At 5:30 a.m. in the morning, Lord, he was admitted to the ESI Kamarhati Hospital. This is, my lord, from the affidavit of the mother at page 118. From the same affidavit, my lord, it would appear that at 10 a.m. in the morning, he came and there was respiratory distress. At about 10 a.m., he came in the ESI ambulance. We tested him because we couldn't take him inside. We did not have, my lord, the benefit of taking COVID patients, which was particularly to be allowed by the government. So, my lord, we tested him in the ambulance. We said you're COVID positive, and we sent him back to the ESI hospital saying we can't admit you, but we have home tested you with that kit which was available at that time. You are COVID positive. Please go back to the government hospital, which is the ESI hospital. ESI then sent him to Sagar Datta Hospital. That was, my lord, at 1:45 in the afternoon. Sagar Datta, another government hospital, sent him to Calcutta Medical College. 4 o'clock in the afternoon, my lord, he was admitted at Calcutta Medical College and he died at 9:45 p.m.
In the Calcutta Medical.
In Calcutta Medical Hospital. His parents were informed at 6 a.m. the next morning. So, my lord, the fault is not mine for diagnosing the fact that this is a COVID positive
And
patient.
what happened in the writ petition? No,
My lord,
they
this
went
is
before the commission.
Yes, it
Now,
has been
initially, yes, we went to commission. Commission ordered to pay rupees 5 lakhs. They challenged. Matter went before the honorable single bench. Single bench also, my lord.
Which commission you went?
My lord, West Bengal Health Regulatory Commission.
How do they?
We have jurisdictional arguments as well.
How they can entertain? Before the consumer court, if you go claiming medical negligence, that route is different. District forum, state commission, national commission.
No, in West Bengal, my lord, West Bengal Health Regulatory Commission has been
Health Regulatory
established.
Commission, which provision
my lord,
covers them to grant compensation?
Yes, I am showing, my lord. Before that, my lord, kindly allow me to file the affidavit in oppositions, which
That you filed.
my lord.
Short issue, sir, whether you want 5 lakhs or not, that's it.
My lord, honorable single bench also admitted that, my lord, that Health Regulatory Commission has passed the reasonable order. I can show, my lord. Let him place.
Reasonable order is different. When they are questioning the jurisdiction of the commission, you are bound to respond. You please show the Clinical Establishments Act, West Bengal Clinical Establishments Act, regulations also.
Can you come back?
All right, which paragraph the learned single bench holds the commission as power?
126.
Page 130, my lord, is the order.
We have got these.
I've got the act.
Server's copy. You tell the paragraph number,
Regulatory
internal
Commission
page,
Act. Page 126. Is
internal page number, paragraph number.
of the writ petition, of the writ single. Material 126 of the pre-application. There is another act, West Bengal Health Regulatory Commission Act.
Whichever enactment you please show.
Yes.
See, last time we were suggesting.
Yes,
Mr.
and we had
Chaudhary
agreed
that
also. We had agreed also.
we will vacate all the observations against him. Preserve the direction issued to the government hospital by giving representation so that they can take back. He will pay you 5 lakhs.
My lord, if they pay, they can.
No, no.
This,
My lord, your
They
lordship-
were not agreed
my
to
lord,
pay
your
5
lordship had
lakhs.
said 5 lakhs. I, my lord, tried to, my lord, persuade your lordships to make it, my lord, a bit lesser. But, my lord, the boy's mother said that I don't want any money. I want.
No, not that, my lord. Initially, order was passed by the West Bengal Health Regulatory Commission. We agreed, but they were saying that we have to withdraw all the allegations. There, my lord, the mother was not agreed for
He
that.
was present in court. No?
Yes, yes.
Today she is not present because, my lord, today she is not present.
And on the
Act to provide for registration, regulation and transparency of clinical establishments of the state and for matters connected. Whereas it is expedient in public interest to provide for registration, regulation, transparency in functioning, clinical licensed under Act to preserve minimum standard of facilities and
Yes.
service provided by them to the service recipients, which is the power grant, the powers for the commission.
Section 38 of the.
তুমি আছো তো তুমি এদিকে চলে এসো আর রেসপন্ডে তো হেলথ রেগুলেটরি কমিশনকে শুনতে চাইছেন তো এদিকে এসো তোমার পাওয়ারটাই তো জানতে চাইছেন
Oh, compensate.
Yes, my lord, yes.
Adjudicate, compensate.
That is there. And that order was established by the Honorable Single Bench. Honorable Single Bench also found that they took the blood sample, went into the nursing home, and in a simple page of paper, my lord, only written COVID positive. Subsequently, it was found that he did not die due to COVID positive. He was not suffering from COVID. But as, my lord, they have observed that the boy was suffering from COVID positive, no other hospital was allowed him. No other hospital admitted him, my lord. Even initial medication was also not provided. No oxygen was provided by any of the hospitals, my lord. Only on the basis of that sheet of paper, wherein it was written COVID positive. Through COVID kit, they were not identified. RT-PCR test, some very, my lord, normal test was done. They said he was suffering from COVID. No other hospital allowed him. Ultimately, he was suffering for my lord, need of oxygen. Oxygen was not provided. He died. 29 তো ঠিক আছে
38 হচ্ছে পাওয়ারটা দেয়া আছে 29 তে পাওয়ার দেয়া আছে যে কিছু একটা পেয়েছো
And where is the certificate which says that he died of some other cause?
কোথায় অ্যানেক্স করেছো
Calcutta Medical College Hospital.
He did not die due to some other cause.
He died.
Oh, sorry. In the post-mortem report, my lord, it will be available. We are showing. Affidavit in the affidavit in opposition, that is, দেখো কপিটা দাও
The affidavit in opposition is there.
এইটা হচ্ছে কোভিড পজিটিভের কথা আর ইয়েটা বার করো
বলো সেটা
অ্যানেক্স করেছে তো
মনে পড়ছে
আমাদের কাছে কোনো কপি নেই এটা
আমার কাছে আমার কাছে নেই
কি বলবো কি
তুই তো বললাম আরটিপিসিআর
আমরা দিয়েছি ওদের কাছে আমি কপি দিয়েছি না তোমাদের কাছে কপি গেছে না আমাদের একটা এফিডেভিট ইন অপোজিশনে
কিছু
কপিটা জেরক্স করিনি আমরা কিছু দিইনি
আমার তো স্কোপ নেই কোনো কিছু
এটা একটু দেওয়া যাবে একটু দিন একটু এটা আর আপনি একটু ওটা একটু এটা দিয়ে দিন এই দুটো কপি দিয়ে দিন যে হি ওয়াজ মানে কোভিড নেগেটিভ COVID negative. Sorry, COVID negative. He did not die due to COVID.
No. When was this test report? Reporting date 17/7. Date of death?
Milord, kindly see, Milord, the date of death is, Milord, 10th of July 2020 at
After his
9:45 p.m. Now, Milord, kindly see page 144. This is the report of the Calcutta Medical College.
No, please, no, once again. Date of death is?
Milord, 10th of July 2020.
But 10th of July.
Yes.
Sample was drawn on 16th.
No, sample was taken earlier.
No.
After the death.
Date
I don't
of
know what
sample
he's showing.
testing is 16/7. When was the sample drawn?
Sample drawn. My lord, sample drawn earlier before his death. But my lord, result came afterwards, after his death.
No, but date and time of receipt is 16 July 2020.
I don't know what my learned friend is showing, Milord.
Test report, RT-PCR.
Milord, please see the
RT-PCR
report.
test report, yes.
But that's also on record. I'll show your lordship. Please see the the report on behalf of the
Sample
Kolkata
testing was
Medical
done
College
after the
at
death.
page 144.
মারা গেছে কবে?
Milord, please see cause of death at Milord paragraph 15 at page 147.
Sorry.
He died from metabolic acidosis in a C/O DKA in type 1 DM patient having COVID-19 illness. This is the report of Kolkata Medical College.
Page?
Milord, page 140, it starts at 144. Milord, this is paragraph 15 at page 147. Milord, please see paragraph 15, Milord.
What is this? This is the affidavit
of the Calcutta Medical College.
Calcutta Medical College.
The medical superintendent come
Where
vice
is the
principal.
postmortem report? This says COVID-19.
My lord, at the last page of our affidavit in opposition.
আমাকে একটা কপি দেবে?
কপি তো আমাদের কাছে সব মিসপ্লেস করেছি, দেখতে পাচ্ছি না। আচ্ছা, ওইখানে ওইভাবে যে এগুলো একটু বড় হিয়ারিং লাগবে, আমরাও তো রেডি না।
কোথায় ওটা সরিয়ে দিলে?
পজিটিভ রিপোর্ট, কোভিড
Also, Milord, please see page 120.
লেটার, হ্যাঁ এখান থেকে শুরু করি। রিপ্লাই টু এ নোটিস, এই যে পেজ 101 দেখি, পেজ 101 থেকে দেখানো শুরু করতে হবে। হ্যাঁ, লেটার, পেজ 1 well known.
10th July on the same date.
কি নয়? আমাদের
Cause of death kept pending. Cause of death kept pending. Till the receipt of chemical history.
কোন পাতাটা দেখালো? প্রথমে যেন কি কোভিড কিট টেস্ট।
এই তো 120।
আমি 101 থেকে দেখাবো।
But cause of death has been kept pending till the receipt of the chemical, histopathological, biochemical, and in fact, if you see the previous paragraph, preserved articles, chemical examination, routine viscera in saturated solution of common salt with control. Number 2, blood without preservative. Then microbiological, nasal swab and nasopharyngeal swab in viral transport medium, VTM, for RT-PCR of COVID-19 test.
They did not do RT-PCR test. They only did COVID kit test. No, sorry,
At
COVID
that time, everything was a
antigen kit
confusion, sir.
test.
Even we didn't get kits, no. Private hospitals did not, were not permitted
My lord,
to admit.
subsequently that was banned. If your lordship kindly comes to page 101 onwards, even
What is the cause of
CMOH.
death? Who appears for the state? I mean, Calcutta. And what happened to the final?
Your lordships can also see, my lord, page 151, which is the Government of West Bengal Department of Health and Family Welfare record. That also says complaint is COVID positive, admit to CPR. Complaint is COVID, there's no determination. Complaint is COVID positive.
Naturally.
He was admitted to
Naturally.
CPR.
Initially, we
Now and then, my lord, he was administered medicines. Ultimately, he
But in
died.
page 147, para 15, they categorically say that with the cause of death being metabolic acidosis in the CODK so-and-so type 1 DM patient having COVID-19 illness.
That was the allegation initially on the basis of the cheat, wherein it was written that he was suffering from COVID.
No, sir, we can't sit in judgment.
My lord, kindly allow me to place page 101 onwards.
That is the issue is because the Clinical Establishment Act can assess the compensation only in a summary manner. Here, you have to fix negligence. Fixing negligence requires evidence.
And
Subsequently, evidence. Subsequently, it was fixed for taking evidence. They did not appear. They are But if your lordship,
where is the rules? Where are the rules?
If your lordship kindly sees the last order, the impugned order, my lord, kindly comes to the last order passed by the West Bengal Health Regulatory Commission. There it was stated that matter was heard in a thorough manner. They did not appear. They have chosen not to appear. If your lordship kindly comes to page 126, this honorable single bench's order, they also found them liable.
No, on the date when the commission inquired the matter, this affidavit was not there. This affidavit has been filed
in the Honorable High Court. In the Honorable High Court.
Because as per the postmortem report, the cause of death was kept pending. Now, this affidavit was filed on 24th of August 2023. So therefore, this clearly says that the patient had COVID-19 illness.
That was said. That was said on the basis of the report given by Midland. All right, my lord, I shall satisfy your lordship. Kindly fix this matter on another date. I shall inquire in again, my lord, from the mother of the boy. Thereafter, again come, my lord. I shall satisfy your lordship.
Three things. This compensation was really fixed by the ad interim order itself. And it was fixed without deciding which of the hospitals is responsible. I only had 15 minutes. And the learned judge says, I am only concerned with Midland because it is a private nursing home. Others are all hospitals, state hospitals, so I don't have jurisdiction. I'm only concerned with you. Why didn't you give him treatment? Now, I can't give him treatment because I'm not permitted to admit a COVID positive
Our
patient.
case is he was not suffering from COVID. Only you have said that he was suffering from COVID. That's why no hospital admitted him. You did not have infrastructure to.
At that time, I was staying in Salt Lake. The first test they took, it was negative. For me, negative. Then they organized another camp in the High Court for all advocates, staff. I was tested positive after 2 days.
Possible. That was RT-PCR test, not by COVID and
the boy did
regular
not
test.
give any of the doctors.
That was banned. CMOH even said. RT-PCR. My lord, all right, my lord, I shall satisfy your lordships. Kindly fix up another date, my lord. I shall.
Question is
the scenario.
Petition.
The scenario, my lord, March 20 to September 2020. Not only one person, entire earth, my lord, was suffering. Whatever is there, and whatever the facilities would be, that was in a particular examination way, everybody was examining how it is to be developed, how the process, what will be the appropriate process so that we can survive.
Initially, no.
That
no
was the thing that was going on in
medication was
first phase.
provided.
And at that point of time, this person was suffering. Actually, scientific kit, whether it was available at all, we
But,
didn't have any knowledge.
See, in the writ petition, certain observations have been made against the hospital and compensation of 5 lakhs has been fixed. What more the mother wants?
Yes.
No, mother is, I shall inquire, my lord, I shall inquire and come on the next date.
Because the mother has not filed a appeal against that order. You are not on appeal. They are on appeal.
No, my lord, we lodged FIR. Initially.
No, that is a separate channel.
No, my lord, final report was filed stating mistake of fact. Thereafter, we have again filed the Naraji petition.
Oh, in that the hospital is arrayed as an accused.
Yes.
I can't pay him compensation and also suffer a criminal proceeding which
There
are parallel lines which will never meet.
Yes, Philip.
They are parallel lines which will never meet.
Yes. But
my lord, they do not have license. Still, they were my lord, doing their business. License expired.
No, that's not the issue.
Yes, all those were the issues.
But then the one thing we have to admit is that there was a complete restriction on admitting patients suspected of COVID even.
In private hospitals.
Suspected
That
of
was
COVID
the
even.
main issue.
They will lock the gates.
I couldn't have taken him in, and I didn't keep him outside for too long. 15 minutes, I did diagnosis and told him, you go back to Sagar Datta Hospital. That's number one. So why should I be held responsible? Now, if for the whole day, culminating in the boy's death, government hospitals didn't do anything, it's their problem. Second issue is compensation is really fixed, and the learned judge, my lord, makes up.
They have challenged the compensation.
Yes,
we have not come before your lordship.
1 minute.
They have come.
Ad interim order.
Had it been a case
Complaint
that they are paying the
received within 5
compensation, we would
minutes
not
you
have come.
decide compensation. Can't be. That is the sum which I was directed to pay by the ad interim order. That is the final order. So where is the question?
Final order because they did not appear. I can show the order from page 72 to 85.
I will make my
72 to 85. They did not appear in the final hearing.
Compensation can't be at the ad interim stage. That
Ad
was
interim stage,
challenged.
you
We
did
didn't
not
succeed.
pay.
I understand. But where is the quantification and why me? There must be apportionment of liability.
The writ petition was filed challenging an interim direction.
Yes, that failed.
That failed.
And the main matter is still pending.
No, main matter also disposed of. There also remain the same amount.
Where is the order?
Yes, 72 onwards.
First is not page 87. This is the first order. Order dated 10th September 2020. I am to.
That order was also
Oh, I'm
challenged
sorry,
for Honorable High Court. Honorable High Court did not interfere. Thereafter, the final hearing took place. Page 72 onwards.
Oh, in that interim order itself, they said deposit of 5 lakhs to the commission. Then 72.
And then Millard comes 72. And Millard, the important part is page 75, last sentence. We are concerned only with Midland Nursing Home being a private clinical establishment under our control.
Yes, as per the law.
No, that's true.
But if you can't apportion liability,
That's the
doctrine of
My lord,
proportionality.
that order was passed by the Honorable Single Bench. Honorable Single Bench also directed that the other hospitals also cannot go scot-free. They also should be liable regarding the death of the boy. That is different issue. But they have come before your lordships challenging the only that part of paying rupees 5 lakhs. They do not want to pay that part. That's all, my lord. Their prayer is only up to that. We shall not pay rupees 5 lakhs.
Millard, page 76 at the bottom, Millard, we are prima facie of the
One
view.
more thing, sir. In the writ petition, none of the 3 government hospitals were respondents.
My lord, they were called on. That's why the medical college, they have filed their affidavit in opposition.
They were impleaded.
Yes, subsequently. Yes. The order.
Where is the corrected cost title? They were impleaded.
Initially, my lord, there was not made party.
Not made party.
Then single bench directed him to implead him as a party. Thereafter, Calcutta Medical College, where he ultimately expired. There, my lord, they have been made a party. And
what about the other two?
Page 130
ESI and
Page
Sagar
130.
Sagar Datta and ESI, they refused to accept only because of that there was no accommodation. That was the plea taken by the state. Only the Calcutta Medical College.
It's not a plea. ESI hospital is the first hospital who refused to accept to admit the patient. Why you are going to forget it, Mr. Banerjee? ESI is run by a center. ESI is
kindly comes to page 141. Page 141.
The darkness yields much light in
Accordingly, WPA number is disposed of without interpreting impugned order. The respondent number 3 is granted
But
liberty.
then the only problem is, it is not the compensation alone. While deciding the correctness, how to apportion the compensation? Because let us assume you have impleted several respondents in a writ petition. 2 respondents are within the territorial jurisdiction of the High Court at Calcutta. Remaining 3 are outside. Can we say that I can exercise only jurisdiction against those 2? Therefore, I issue a mandamus against 2. Remaining, you go and see elsewhere in Jharkhand or Odisha. Can that be done? Compensation, if it is to be fixed, though there may be 5 parties, you exonerate everybody. These 2 hospitals did nothing because they said lack of accommodation. So they cannot be. Then was he right in saying that COVID-19? Then what was the cause of death in Calcutta Medical College Hospital? So was there negligence on his part? Was there negligence on the part of the time taken for admission, etc., etc.? That's how you determine compensation.
That was determined in the order passed by the Honorable West Bengal Health Regulatory Commission as well as by the Honorable Single Bench. What happened? Other hospitals, they did not admit me only on the basis of their report, which was false.
But then the tribunal says, commission says, we are concerned only with midlife.
Yes, as per the law.
So can you do that?
My lord, as per the law.
You have gone collectively. Where is your petition before the commission?
Petition before the commission. Yes, I have.
Copy.
No, the complaint.
Page
118. No, this is affidavit.
No, this is not the affidavit. This is the affidavit.
This is the complaint.
Are you having it in your writ file? It will be there.
Yes, we have, my lord. We are placing, my lord.
Page 118 is the version they were relying on, but
no, that's a very short affidavit. Your affidavit in opposition,
my lord, we have annex actually. Complaint দেখো না, রিটের কপিটা দেখো না, রিটেই আছে। Interim order 5 lakhs, reply notice.
So this is actually 118 is the affidavit of the complainant. I think this is the complaint. This is the complaint, Lord. This is what we were served with.
Page?
Lord, 118.
By way of an affidavit.
This is the affidavit, the complaint. Yeah.
There is one complaint in page 63 of the affidavit in opposition.
Notice.
Annexure P15 appeal.
Pleading. যে কমপ্লেন না এটা কমপ্লেনের অর্ডারটা ওখানে কি হচ্ছে রে ওখানে কি হচ্ছে ভাস্কর ওখানে উঠে যাচ্ছে যাক
And Milord, the whole judgment has gone against me on the ground that I refused preliminary aid. Without, Milord, the learned judge of the Honorable Commission having come to a conclusion that what preliminary aid was required at that stage. Because he came to me in 15 minutes. I told him he was COVID positive and I sent him back to Milord Sagar Datta, a government hospital, which could have admitted patients. Now, the timeline is very crucial. He comes, Milord, at 10 o'clock in the morning, and at 10 minutes past 10, I tell him, what is your problem? And I sent him back to Milord ESI hospital because he was already in the ESI hospital ambulance. So that 10 minutes I have with him, from 5:30 in the morning till 10 o'clock, ESI hospital had him, did nothing. Then Milord, from 10 past 10, after I sent him back, till 1:45, he was at ESI in the afternoon. He was at ESI hospital. They did nothing. At 1:45, he was at Sagar Datta. So I'm sorry, Milord, my mistake. He was at ESI till 1:45. 1:45 in the afternoon, he was sent to Sagar Datta. Then he was sent to Calcutta Medical College. He was finally admitted at 4 o'clock in the afternoon in Calcutta Medical College. They didn't put him inside the ICU, and the boy unfortunately died at 9:45.
No, my lord, the case is not
And
like that.
I am liable.
I am telling
for that 10
what happened on
minutes
that day.
at 10 o'clock in the morning.
But I am telling, my lord.
In your affidavit in opposition, page 34, you have annexed the emergency assessment sheet of Midland Hospital.
My lord, in their appeal, kindly comes to page 122.
No, let me
My
complete
lord.
the sentence.
Before that, Milord, I'll
Enclose the emergency assessment sheet.
My lord.
Discredit this document. You have to discredit this document to hold him responsible. Your complaint, mother complaints is, they simply wrote COVID positive, simply wrote COVID positive.
Yes, that is true.
That has to be established.
Yes, my lord. Now, my lord, what happened that regarding the timeline, my learned friend said, what happened? If your lordship kindly comes to page 122 of their appeal, kindly comes, my lord, 122, only in a page they said COVID positive. This was the paper which was done enough damage. No hospital.
Sir, the same paper is there in.
All right, my lord,
affidavit in
kindly
opposition.
appreciate, my lord.
How do you discredit this noting? Somebody technical should say this is wrong.
Yes, my lord. The CMOH himself stated, in this way, COVID positive test cannot be done. That was not the medical guideline. Not only that, subsequently it was seen that the boy did not die due to COVID. That document I shall place on the next date.
The affidavit filed by the Medical College Hospital says he was COVID positive.
My lord, the
That
postmortem.
affidavit was filed in the writ petition much after the commission's order.
My lord, I shall show that document only wherein it proves that he did not die due to COVID. And my lord, what happened regarding the timeline? He is saying this boy in front of me, this mother in front of media started saying, if any hospital they do not admit my son, I shall commit suicide on the footpath. Thereafter, the police came and police ordered a government hospital to my lord, admit his son. Subsequently, this is not such a case as my learned friends said that one hospital after another hospital he only shifted. Not a case like that, my lord. No hospital was ready to admit my son. Ultimately, police forced them to admit my son. That's why the one government hospital admitted my son. But within that period of time, enough damage was done. My son died.
The timeline I gave your lordship is from his pleading.
I shall show that was not my
please have a look at his complaint.
What is the stage of the criminal proceedings?
My lord, Naraji petition is pending. That's up to that I know, my lord. I shall take instruction, my lord, in between if any progress.
And they are the sole accused.
My lord, that
police has exonerated us, I'm now told. FRT filed, but they will challenge it. I'm sure
I have challenged. That I know.
I'm sure he will be
challenged.
Naraji petition filed.
All right.
Now, my lord, the timeline which I, my lord, gave your lordship, please, my lord, see page 118. This is my learned friend's affidavit, where, my lord, he says that at paragraph 3, 5:30 a.m. on 10th July, We took him to Kamarhati ESI hospital. And certain preliminary medical tests were done and he was advised to go to Midland, which is me. And paragraph 4, ESI arranged for their own ambulance for our son and we reached Midland Hospital at 10 a.m.
Well, subject to Lordship's kind sanction, a government hospital cannot have any authority to direct to go to a private hospital. That is misleading statement.
So this is him. This is him. This is not me.
Again, that is there again.
So, my lord, from 5:30 till 10, it was, my lord, ESI hospital. Then, my lord, please see.
No, ESI was not a party. Otherwise, in the case sheet,
Yes.
they would have recorded against advice. Any government hospital, when you want to shift the patient, it is at the patient party's risk.
Yes.
And they will record in the case sheet against advice.
Against advice.
Yes.
My lord, ESI
No, before you
hospital had
start
tie
again,
up.
Because of the situation, humanitarian basis, they would have provided the ambulance.
Yes, yes.
My lord, they had tie up
Father
with
was an employee, central government employee, is it?
Yes.
Boy's father.
Yes, father.
All right, you find out, sir, if suppose the criminal case they don't want to do, we'll try to do something, matter can be put to rest.
My lord, I shall take the instruction.
I'm still ready. Let him accept the criminal court judgment. It's an unfortunate incident, my lord. We have agreed to, my lord, make payment of rupees 3
Had it
lakhs
been a
to
case they had made payment, we would not have come before your lordship. But you pay the amount.
Yeah.
No, the findings will adversely affect them. These findings, it will get uploaded in the commission's website. High Court order uploaded. So this will become a badge for him.
No, moreover, my lord, the impact of my writ petition being dismissed on the criminal court will be very serious.
Thirdly, commission will refuse to renew his license.
My lord, they are not renewing their license since, my lord, long back, my lord. They are not renewing their license. Still, they are doing their business. That is separate issue.
Find out whether you have a license.
All right.
I'm sure we have a license.
My lord, only a one humble prayer. Can I take back the affidavit in oppositions, my lord? We shall make photocopy and, my lord, we shall serve upon them. Unfortunately, we have misplaced those documents, my lord. Grateful, my lord.
And you also get a copy of the petition filed before the commission.
My lord. My lord, online we applied. We shall collect the copy, my lord.
You give a date after 2 weeks. Meantime, Mr. Chatterjee,
My lord, I shall ask.
to your
I shall
client,
take instruction.
something can be done. Because asking you to give a representation of director of health, etc., it's not going to take you anywhere.
My lord.
It is like Ganges joining the Bay of Bengal.
Yes.
Matter is over. Next.
Grateful, my lord.
Serial number 29. Serial number 29.
I beg to appear on behalf of the applicant. So this matter is very interesting point that the Lordship sitting by Justice Bhattacharya heard this matter and that vividly that formulated the points.
So we will, that bench itself we will hear.
Yes, yes.
Since the other honorable
Written notes of.
had heard.
No, I was directed to file the
extensively,
compilation.
Let this appeal be listed before the appropriate division.
Notes may be filed today.
Well, this is the compilation.
What is that?
So this is the
Written notes,
compilation.
compilation.
No, you have it on the next date when it's listed on that day.
Mother, that is written with position, mother.
Yes, yes, in the same. No, that will be a very short list. Yes, yes. Other matter, we are segregating all these matters.
Absolutely.
Next.
About.
Serial number 30.
30, 31, 32, 33.
GST refund.
My lord, appearing for the petition appellant, my lord, I'm being led by Mr. Shubhopra Datta. My lord, kindly praying for not today, my lord.
Not today will never come this year, sir. 2026 only.
I beseech to your lordship, my
I
lord.
will not be here. Don't worry. Well, let it be in the list. We'll say not today.
Obliged, my lord.
Next.
Deeply obliged.
Serial number 31.
No, same, sir.
Up to 33.
30 to
30, 31,
33.
32, 33.
33, my lord.
30 to 33.
Call 34 and 35.
Serial number 36.
34.
34, 30.
34.
34, my lord, I beg to appear on behalf of the respondent, my lord.
Yes, sir.
It's the state superior, your lordship would remember, my lord, that Shia Islamic theology person in the Waqf board did not have any sort of a degree or, my lord, any sort of an experience. But it is the state's appeal, my lord, so I am the respondent, my lord. I succeeded before the learned single judge, my lord.
And
Your lord,
there is
not
there's another party who's filed an appeal.
Yes, my lord. The person who was removed, my lord.
And there is no interim order.
There is no interim order.
Why it is coming like this?
Your lordship did not give any relief to them, my lord, at the first instance.
You check the earlier order. Why it was because these are all have to be heard. It can't be at the admission, adjourned admission stage.
So one interim order was passed, my lord. I think it was on 7th of February or 24th of June, my lord, 2024. When your lordship said no relief and he would not be attending the proceeding before the Waqf board, my lord. That order was passed, my lord. 24th of June, my lord.
By order dated 24/6/2024, direction was issued to the appellant state to comply with the direction issued by the learned single bench, making it clear that the same will be subject to the outcome of the appeals in MAT 264 of 2024 and MAT 537 of 2024. In the light of the same, sister, the said direction shall be implemented if not already implemented, and the same position will continue till the disposal of the appeals. With the above observation, the stay petition stands disposed of. Let the appeals be listed under the caption for hearing after 2 months. Next.
Greatly obliged.
Serial number 36.
2 or 3 months you give it.
My lord, in this matter, I am appearing on behalf of the respondent, my lord. It's relating to tender matter, my lord. Matter is relating to tender matter. Already a new person already entered and the time is almost over, my lord. Because the
My lord, I laid by advocate Satyajit Sinha Roy, my lord. He
You're
cannot.
led by?
Satyajit Sinha Roy, advocate, my lord. He cannot appear due to his certain
For
hip
something
test,
he
my
was
lord.
there.
He got his leg injury, my lord. I'm praying for not today, my lord.
tender floated in the year 2023 to 31st December 2023. The writ petitioner left the job. And 1st January 2024, the new person already entered appearance. The tender is at the vergent, flag end of the.
That tender for supply of cooked items.
Yes, my lord.
For how many years?
For 2 years.
You show the tender page from what date to what date?
My lord, my
No,
brief is not
we'll
here.
find out.
अपनी कार घुमा दे। थोड़ा टाइम चाहिए, थोड़ा टाइम चाहिए।
But the same doesn't say.
Qualification eligible contract for that is successful.
My lord, kindly comment to page number 55. Period of contract, clause 4, that is for 730 days, my lord.
55.
Page 55, clause 4. My lord, I am led by Mr. Banerjee, my lord. No,
730 days.
730.
On what date work order was issued?
In the month of, work order issued in the month of December 2023. And the work starts from 1st January 2024. That matter is filed after work already starts.
So no interim order was
But
there.
I
No, my
have no
lord.
knowledge, my lord. Kindly keep the matter day after tomorrow or next day, my lord. I'm praying for not today, my lord. I have no knowledge regarding this matter.
It is already 1 year over, my lord, in the contract. More than 1 year.
My lord, kindly keep the matter day after tomorrow. My humble prayer is, my lord. I'm praying for not.
Not today.
I'm grateful. I'm grateful.
Lord, you kindly,
So it will continue in the list. Let us see. When it will come? Wednesday it will come.
Lord, you kindly record the.
If we say not today, it will remain in the list. So we'll stop with this. Sir. So tomorrow same list will continue. Who? With whom?